I'll add one submission.
Yes, yes.
Final hearing matter, memo for posting,
Which year? Which year?
2019.
Yeah, in matter.
302, convicted,
How many years in custody?
11 years. IA is pending, my lord. That's why they are not.
Put it.
I will. I will not press today, man. Fine.
Why you kept quiet for 11 years?
It is no objection. Bandidana.
I don't understand. I absolutely don't understand. ಬೆಂಚ್ ನೋಡ್ಕೊಂಡು ಮೂವ್ ಮಾಡೋದು ಬಿಟ್ಬಿಡ್ಬೇಕು. ಒಂದು ಎರಡನೇದು 11 ವರ್ಷ ನೀವು ಸುಮ್ಮನಿರೋದು ಇಟ್ಸ್ ಅನ್ಪಾರ್ಡನಬಲ್. ಕೊಡಿ. You must be ready. When will you be ready?
Monday.
On any date.
Yes. ಕೊಡಿ.
Page wise adjournment, page number 2, 29, page number 3.
Your Lordship, serial number 6, Your Lordship, appearing for the petitioners. Kindly a week's accommodation, Your Lordship. I have informed the other side.
That request is the matter week after next.
Obliged.
Page number 3, serial number 10 to 12.
Serial number 11. Number 3, serial number 11.
Serial number? 11.
I have it next week, my lord.
You inform the other side.
I'll inform, my lord.
That request, you must inform in advance so that they also need not.
29th or 30th.
Huh?
30th.
Correct, I'm saying you must inform in advance so that they know they don't have to be ready.
Vijay Kumar is on time.
ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಅವ್ರ ಕೊಲಿಗಿದ್ದಾರೆ.
He is here.
ಕರೀರಿ. ಇಲ್ಲ ಆಯ್ತು, ಅವ್ರೇನೋ ಟೈಮ್ ತಗೊಂತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಡೇಟ್ ರೀಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ. ಎಸ್ ವಿಜಯ್ ಕುಮಾರ್, ದೇ ಮೂವಿಂಗ್ ಫಾರ್ ಟೈಮ್ ವಿಲ್ ಬಿ ರೀಫಿಕ್ಸ್ a date.
Please. 29th or 30th.
Date ಕೊಡಿ.
Page number
Please.
My lord, serial number 10, I am the respondent. The cross appeal of the claimant, the Manvendra Reddy will be appellant. I will be next week, I will be appointed. Because of, so that I will be filed a synopsis in the connected matter and other matters. Next week at any date.
It can be disposed of, is it?
Yes, my lord, because only capitalization method,
Capitalization.
whether it has to be taken, sugarcane has to be considered, like jaggery has to be taken. That is only the minor issue.
So
And
far is
wherever
the
some matters are pending before district court, they are pressing. The anxiety is there are connected matters are pending there. For that court, there is no work. Some matters here pending unless. Malad,
ಅವರೇ ಮಾಡ್ಬೋದು.
ಇದ್ಮೇಲೆ ಈ ಡಿವಿಷನ್ ಮ್ಯಾಟ್ ಕನೆಕ್ಟೆಡ್ ಕಾಮನ್ ಮ್ಯಾಟರ್ ಇದ್ದಾಗ.
ಅಲ್ಲ ಅವ್ರ ಪಾಪ ಕೆಲಸ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಮಾಡ್ಬೋದು. Relist on date ಕೊಡಿ.
7th of February.
please.
ಅಲ್ಲ, if you feel you can take a chance there, we can clarify that these will not come in the way often.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದ್ದಾಗ ಹಬ್ಬ ಬೈಂಡಿಂಗ್ ಇದು ಬರ್ತಾರೆ. ಕಾಮನ್ ಮ್ಯಾಟರ್ಸ್ ಇರುತ್ತವ. That is.
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಅಟ್ಲೀಸ್ಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ then you have another appeal, isn't it?
Other is connected. Some matters less than 10 lakhs rupees are pending.
Next.
Page number 4, serial number 30 to 50. Page number 5, serial number 16 to 50. Page number 6, 31 to 50.
Bill number 24.
Yes.
I am for appellant in this case, my lords, in connected matter. My lords, other side was not ready and he not come, my lords. 24. Our time ತಗೊಂಡಿದ್ರಿ ಅವರು.
Relist on date.
Serial number 1, pronouncement of judgment. Sachin M. Mahajan, Shivanand Patil.
Appeals are rejected. I under 41 rule 27 is also rejected.
ಒಳ್ಳೇದು.
PS Malipati,
But I appear for the appellant, not for the present, not my submissions may not may be accepted and it may be posted for admission on 7th, not.
What is the office objection? ಏನು ಕೇಳ್ಸಲ್ಲ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
Now, record of rights have been produced, which are not concerned to the subject matter of the writ petition. But many of the documents were produced, and whatever the copy was furnished to me, I have, as it is, I have produced
No, other-
before.
No, Mr. Mali Patil.
Yes, madam.
ಬೇರೆದೆಲ್ಲ ಇದೆಯಲ್ಲ, ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿಲ್ಲ.
Court fee ಕೊಡ್ತೀವಿ, I'm sorry. Court fee.
ಇಲ್ಲ, ಬಟ್ ಅದೇ ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಅಟೆಸ್ಟ್ ಆಗಿಲ್ಲ.
ಅವೆಲ್ಲ
ಬೇರೆದೆಲ್ಲ ಇದೆ, ಚೆಕ್ ಮಾಡಿ.
ಮಾಡ್ತೀವಿ. Yes,
for admission, I'll give a date. By then you clarify.
please, Your Honor.
One
His objections to be complied by
on
the
submission.
next date. A list
It's
of
a
matter,
order-
the admission list on date could.
It's order against not passed by the learned single judge under Article 227. The writ petition
no.
itself is not maintainable.
No, I'm sorry. Your Lordship may hear this matter.
Just 1 minute. Just
No, 1 minute I will submit.
ಅಲ್ಲ, ಅದು ಲೇಬರ್ ಕೋರ್ಟ್ ಇಲ್ಲಿ ಅದೇ ರೀತಿ ಲಾಜಿಕ್ ಇಲ್ಲಿ ಅಂತ.
Labor court logic alla. There are other judgments, followers, even by this honorable court, division bench, relying on the earlier full bench court judgment. Even under my lords, the order against the
I will comply, my lord, orders.
ನೋಡೋಣ, let us. Practice ಅಲ್ಲಿ we are entertaining, isn't it? ನೋಡೋಣ.
but entertaining the SLP filed against the order is also dismissed.
ಇಲ್ಲ, ಅದು ಲೇಬರ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್.
And
ಅದು ಲೇಬರ್
the
ಮ್ಯಾಟರ್.
that
ಅದು ಲೇಬರ್ ಮ್ಯಾಟರ್. ಒಂದು. ಎರಡನೇ, this is the practice we are following. If at all it has to be heard, we'll consider in a.
not even that apart also, it's order wherein the learned single judge has remitted to the deputy
That
commissioner.
we'll see, that will accept.
Now
yes.
by virtue of the interim order, we are not in a position to continue any, because
We'll examine it, we'll examine it.
any date not, sir.
Date could. 10th of February.
So early date, because it's a matter wherein from 2000 they are fighting.
Let us come prepared. Yes.
Yes, my lord.
Appaji,
Your Lordship, the respondent husband had filed a petition for restitution of conjugal rights, which was allowed. That was challenged before this honorable court by the wife, Your Lordship. Now the matter was referred to the mediation and the parties have settled the matter, Your Lordship. They are present before the,
What are the
Lordship.
terms of settlement?
with regard to, it has been put in writing, Your Lordship, before the mediations.
Just put it forth, let us see what,
Please, Your Lordship.
just go to. What it is. Okay. Okay, but what are the terms of the settlement? Just tell us.
Lords, there was arrears, my lord, of 3 lakhs, that will be paid in 2 parts, my lord.
Paid in two
Two,
parts.
2 installments.
Ah.
One in June 2025, my lord, 1.5 lakhs will be given. Thereafter, October 2025, another remaining 1.5 lakhs will be given. And since, my lord, after this settlement itself, both are residing here in Gulbarga for till June 2025, my lord. Since after academic year of June, my lord, he is a BMTC employee, my lord, Bangalore. The family will be residing along with them in Bangalore itself.
So they have agreed to stay together.
Yes, yes.
Please, Lordship.
After a long gap of 9.5 years.
Good. ಇವಾಗ ಇಬ್ರು ಜೊತೆಲಿರಕ್ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ? ಹಾ? ಇವಾಗ 101 ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಬರುತ್ತೆ ಗಂಡ ಹೆಂಡತಿ ಅಂದ್ರೆ. ಗಂಡ ಹೆಂಡತಿಯಲ್ಲೇ ಜಗಳ ಆಗ್ಬೇಕು, ಬೇರೆಯವ್ರ ಹತ್ರ ಜಗಳ ಆಡಕ್ಕಾಗತ್ತಾ? ಬಂದಿದ್ನ ಹಂಗೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ಇವಾಗ ಹೆಂಡತಿ ಅಂತ ನೀನ್ ಜಗಳ ಮಾಡ್ತೀಯ, ಗಂಡ ಅಂತ ಜಗಳ ಮಾಡ್ತೀರಾ, ಬೇರೆಯವ್ರ ಜೊತೆಗೆ ಜಗಳ ಮಾಡಕ್ಕಾಗತ್ತಾ? ಸೊ ಏನೋ ಬರುತ್ತೆ, ಅದೆಲ್ಲರಲ್ಲೂ ಸಣ್ಣ ಪುಟ್ಟ ಬರುತ್ತೆ. ಇವಾಗ ನೀವು ಒಟ್ಟಿಗೆ ಇರಕ್ಕೆ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ, ಒಳ್ಳೇದು, ಅದು ಮಗುಗೂ ಒಳ್ಳೇದು. ಇವಾಗ ಏನೋ ನೀವಿಬ್ರು ಚೈಲ್ಡ್ ಇಸ್ ದೇರ್ isn't it?
Two issues.
Children, two
ಇವಾಗ
issues are there.
ನೀವಿಬ್ರು ಜಗಳ ಆಡ್ಬೋದು, ಬಟ್ ಮಕ್ಳಿಗೆ ಇಬ್ರು ಪ್ರೀತಿ ಬೇಕಾಗುತ್ತೆ. ಅದಕ್ಕೆ ಚೆನ್ನಾಗಿ ನಡ್ಸ್ಕೊಂಡು memorandum of settlement under section 89 of CPC placed before the court in the present appeal. Both parties affirm to the terms set out in the memorandum of settlement and submit that they would reside together as husband and wife, and all disputes are settled in terms of the averments in the memorandum of settlement. Light as the same appeal is disposed of, the judgment and decree of the trial court is substituted by the terms as contained in the memorandum of settlement.
Grateful Lordship.
The parties affirm terms of the memorandum of settlement, which has been read out and explained to them. We find that the memorandum of settlement is also in accordance with law.
Mahantesh Patil.
Filing the, my lord, report CDR details and the CCTV footage of medical shop. They are still in search. Even in Atmapur police station nearby.
Have you got this one telephonic call, this one details of that Ravi Gowda? Friend of that person, friend of the missing person, Ravi Gowda.
Ravi Gowda. Details ಇದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಆ ನಂಬರ್ ಇದೆ. I will mark out my lord. ಯಾವಾಗ ಮಾತಾಡಿದರೆ ಎಂದು I will take. This is the report they have submitted. My lord, I have asked the officials to present.
Where is the office? See, this
Yes,
is
my
not
lord,
the way.
I'm sorry.
Your officials should present.
Yes,
Will issue warrant, let him come. What is one kind of this is not the way. In a serious
I
matter,
asked,
where
yes,
this purpose?
ಅದಕ್ಕೆ ನಾನು ಮೊದಲೇ ಹೇಳಿದ್ದೀನಿ.
By 12:30. Let him come 12:30, we'll pass over.
ಅಲ್ಲಿ ಲಿಂಗ್ಸೂಗರ್ ಮಸ್ಕಿಯಿಂದ ಬರೋದು ಕಷ್ಟ ಸ್ವಾಮಿ, ಒಂದು 200 ಕಿಲೋಮೀಟರ್ ಮೇಲಾಗುತ್ತೆ. ಲಿಂಗ್ಸೂಗರ್ 165, ಅಲ್ಲಿಂದ ಒಂದು 40-50 ಇದೆ. ನೀವು ಸೋಮವಾರ ಇಟ್ಕೊಂಡ್ರೆ ನಾನು ಕರೆಸ್ತೀನಿ. Let my friend go through this report.
Through VC, let him appear.
Through VC.
Telephonically, we'll share the link. Through VC, let him appear.
I ask him.
2:30,
2:30.
you ask him to appear.
Monday 10:30ಗೆ ಇರಕ್ಕೆ ಹೇಳ್ತೀನಿ ಸುಮ್ಮನೆ.
No, we wanted to find out.
Some constable ಬಂದಿದ್ರು. That is why my lord, I have also informed them seriously.
A case where you're simply missing, he expresses some doubt with
Yes,
somebody.
my lord, on
against
some
somebody.
persons. Yes, my lord. ನಾ ಹೇಳಿದ್ದೀನಿ ಇದು. ಹೇಳಿದ್ದೀನಿ
Monday, Monday. let
ಮಂಡೆ
it-
ಆಯ್ತು.
Mahantesh, you go to
I will
the
get,
report.
I will go through and get the instruction.
through
I
the
will call the party.
Go through the report.
Yes. Ma'am.
Serial number 5. SS Mamadou.
For the petitioner.
My lord, in this matter, statement of objections, my lord, ಅಲ್ಲೇ ರೆಡಿ ಮಾಡಿ ಕಳ್ಸಿದ್ದಾರೆ. Once I will go through. ಬೆಳಿಗ್ಗೆನೆ ಬಂದು ರೆಡಿ ಮಾಡಿದ್ದಾರೆ. ಏನಾರು ಇದ್ರೆ ನಾನು ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ಸಮಸ್ಯೆ ಆಗುತ್ತೆ. I will go through and file in the registry. I request your lordship, this also be taken on Monday. ಇಲ್ಲ ನಾನ್ ರೆಡಿ ಮಾಡಿದ್ರೆ there is no problem. ಆಗ್ಬಿಟ್ಟು ಏನಾರು ಬರ್ದಿದ್ರು ಅದಕ್ಕೆ
Monday.
ಪ್ಲೀಸ್ my lord.
In fact, on one occasion, my lords, on one line, lordship, my lordship, one line, ನಾನು ಓದ್ಬಿಡ್ತೀನಿ ಫಾರ್ಮಲ್.
Melkanda, Lords, earlier the detaining authority, that is the district magistrate, he had rejected the proposal for detaining the Lords detainee under the provisions of the act on the ground that there are no sufficient cases against the detainee. And Lords, again, once Lords after that, once again the Lords detaining authority, sponsoring authority, they again submit a proposal with the very same old cases, and again Lords, this order is passed.
Identical.
Identical Lords. And as on that date, all those cases which are alleged to have been registered against the detainee, they were all Lords within the knowledge of the authorities. Adanna ಇದು ಕಂಪೈಲೇಷನ್ ಅಲ್ಲಿ ಇದೆ 1 second ತಾವು ನೋಡ್ಬೇಕು. So it could also help learned GA to meet that point on Monday again.
Correct. We don't want to become like
ಇದು ದಪ್ಪ ಅನ್ಪಿಸ್ಬೇಕು.
government. We don't want to be government. We don't want to become like Telangana, where Supreme Court has observed repeatedly power is being exercised. Should be the responsibility. If it's a genuine case, we are with you.
And procedural safeguard is only.
Yes.
Lords, the compilation page number 1, Lords, just after the APMC police Thane Vijaypur admele, first page of the compilation.
Yes.
It is dated 18/9/2024. It is submitted to the district magistrate. Reference number 2, Lords, kindly please. ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಾರ್ಯಾಲಯದ ಪತ್ರ ಸಂಖ್ಯೆ RB-MAG ಗುಂಡಾ ಕಾಯ್ದೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 11/9/2024. Then Lords, kindly take to Lords of the very same document last page, Lords. It is not numbered. Last page, that is paragraph 7.
7.
Yes, ma'am. It is Lords almost 7 to 8 pages.
Parvati Police Thane, Pune City. That
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಹೌದು, Parvati Police Station. ಅದೇ.
ಇಲ್ಲ, this is the last page of that particular letter. It is
Roman number melod 62. Roman 62 ಗಿಂತ ಮೊದಲು ಎಡಗಡೆಗೆ.
ಖಂಡಿಕೆ 7.
ಖಂಡಿಕೆ 7
7 ಖಂಡಿಕೆ 7ರಲ್ಲಿ ಎರಡನೇ ಈ ಕಡೆ
ಅದರ ಬ್ಯಾಕ್ ಪೇಜ್
ಈತನ ಮೇಲೆ
7ರಲ್ಲಿ 7.
7 ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ನಮೂದಿಸಿರಂತೆ ಮಾನ್ಯ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಂತೆ ಪರಿಶೀಲಿಸಿ ಗುಂಡಾ ಆಸಾಮಿಯ ಮೇಲೆ ಹೊಸದಾಗಿ ಯಾವುದಾದರೂ ಪ್ರಕರಣಗಳು ದಾಖಲಾದ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಸಲ್ಲಿಸುವಂತೆ ಸೂಚಿಸಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಮರಳಿ ಕಳಿಸಿದ್ದು ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಂತೆ ಪರಿಶೀಲಿಸಿ ಸದರಿಯವನ ಮೇಲೆ ಹೊಸದಾಗಿ ದಾಖಲಾದ ಪ್ರಕರಣವನ್ನು ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಸಲ್ಲಿಸಿದ್ದು ಇರುತ್ತದೆ. This letter is dated Lords 18/9/2024. The last case Lords alleged to be registered against this detainee is at Lords page number 1035, Lords, last page of the Lords.
Yes, tell us when is the last date case registered?
That is on 23/7/24.
23/7/24. 2024.
Yes, Lords.
When Gunda Act invoked?
It is invoked on 18/9/24.
18/9/2024. Just 2 months.
Oh, immediately.
Immediately, there is no proximity is there, live proximity 18/9.
Allala, my submission is this last of the FIR crime case.
We are saying there is no fresh case.
No fresh cases.
So the
This case was already there, registered.
previous letter was sent on.
That Lords is not there, but as on 18/20/24 and Lords wide letter 11/9/2024, the detaining authority had rejected the proposal for detention
11-9,
2024.
where is that?
My lords, that is just which I read at the,
ಮೇಲ್ಕಂಡ ಎರಡರಲ್ಲಿ ಸೂಚಿಸಿದರಂತೆ.
yes,
That is reference to na ಅದು.
yeah, house
11-9-24.
24.
ಅದು ಕಾಪಿ ಇದೆಯಾ ಅದು?
ಅದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಮ ಹತ್ರ, ಇದನ್ನೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಆಯ್ತಾ, just 11-9-24 just get it. ಉಲ್ಲೇಖ 2 at page 1. 11-9-24.
That report.
one.
Yes,
Okay, so then they resubmitted when?
18/9/24.
18-9.
Yes, within 7 days they submit.
And there's no other case between 11-9 and 18-9.
No.
Hmm.
And this is also, my lords, act of, my lords, vindication. They, my lords, intentionally, my lords, and even, my lords, this last of the FIRs.
The only ground, what is the?
Other ground is, my lords, in the last of the FIR, what is produced is only the FIR copy. There is no complaint. There is no, my lords, whether I have been enlarged on bail is not forthcoming. Whether I have filed bail application, that is not forthcoming. And my lords, I am a married person. This proposal for detaining me, that is the detinue, is on the basis that I am an unmarried person. The petition is filed, my lords, this indicates that the detaining authority was not submitted with all, my lords, material regarding the detinue. And procedural safeguard is only defense, my lords, available to a detinue under the provisions of this act. Unless the, my lords, procedures as contemplated under the act are, my lords, followed in strictly, my lords, then, my lords, this order of detention cannot be sustained. Thereafter, my lords, even after detention, my lords, the detinue has to be placed before the advisory board within 21 days from the date of detention. That is not done. That is beyond 21, and it is also a mandatory requirement. What was, my lords, so, my lords, urgency, I don't understand, because 11-9 there is a rejection.
You make a note by Monday.
Yes.
Setting out grounds.
Yes.
And
Well,
page
lords,
numbers.
whatever lords, documents are available with me, supplied to the detinue, on that basis, I
Correct.
will make a,
So make
lords,
a note.
synopsis.
Make a note so that if we were to dictate
Yes,
page number, what is the ground,
yes,
which letter,
yes,
page number, so it becomes easier.
yes. Chronologically, my lords, I can,
ಹಾಕಿದ್ರೆ ನಮ್ಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
yes, my lords.
Pagination ಮಾಡಿ.
ಇಲ್ಲ, pagination ಇದೆ ಸ್ವಾಮಿ. ಅದು first ಒಂದು 4 page.
You can put flags,
Yes,
post-its,
yes.
to make it so that it becomes easier time of argument or even dictation.
Please, that.
Due to non-production of the documents, relevant documents, it is difficult for you to.
Make effective representation.
That you have to make.
And I don't know what is there in the complaint, except, my lords, furnishing copy of FIR would not, my lords, in fact,
Total 8 cases, my lord, in 3 police station, APMC police station, Dakota police station and Adarsh Nagar police station. 5,
What is the law? Supreme Court, Honorable Supreme Court repeatedly said, If he is an habitual offender, what is the remedy for you? To apply for cancellation of bail. Instead, you are invoking Gunda Act. Day in and day out, you are invoking Gunda Act. The right and personal liberty of individual is involved.
5 cases are trial is, my lord, going on.
That is not the criteria.
On each ground, there are decisions.
Yes, yes, my lords.
So
Yes.
ನೀವು
I have made out a list of my lords
correct. So in
citation.
your synopsis, including this bail orders,
Yes,
copy is not given.
yes,
So you
I have
make-
my lords. In
correct.
fact,
So you make like that, so that argument time it's easier.
on each point, my lords, I'll,
Authority, paragraph number,
yes,
what is the ground? What are the documents relied upon? What is the authority? On every ground, there's one authority, including this bail order.
bail
ಅದ್ರ
order.
ಮೇಲೆ ಯಾವ್ದೋ ಒಂದು judgment ಇದೆ.
ಇದೆ,
So you refer, come ready. come.
please. ಮಂಗಳವಾರ ಇಟ್ಕೊಂಡ್ಬಿಡೋಣ, ಸೋಮವಾರ, ನಾಳೆ ಒಂದು, ಮಂಡೇ ಇರ್ಲಿ.
Yes.
7, GG Chagashetti.
I am appearing for the appointments. There is a delay of 3 days in filing the appeal. Notice has to go.
You should notice on I as well as me, teacher to be summoned for you.
But they be one Guntikar.
Lordships, appearing on behalf of Uday P. and Guntikar, Your Lordships. This is a company appeal and an injury case, Your Lordships. I am challenging quantum in this matter, Your Lordships. The issue is disability is 44, disability as laid down by the doctor, Your Lordships, is 44%, Your Lordships. But on the whole body, 1/3 had to be considered while computing the compensation, but they have not considered, they have taken it 40% only, Your Lordships. That's why I'm challenging the quantum, and there is also in the aspect of food and nourishment.
Pending consideration of IA 1 and 2 of 25, the operation and execution of the impugned judgment and award is stayed subject to appellate depositing 50% of the award amount before this court within 4 weeks. from
Obliged,
today. The respondents are permitted to withdraw. On such deposit, the respondents are permitted to withdraw 50% of the deposited amount.
Obliged.
Issue notice to respondents.
Call for TCR. sir.
The registry is directed to secure the TCR.
Obliged, Lordships.
GG Chagashetti.
I am appearing for the complainant. Your office may kindly refer to page number 9, direction issued by the learned single judge. There are 2. In these correct representations, the petitioner is seeking for a promotion from the post of FDA to that of assistant librarian. Since the petitioner is claiming that he is entitled for a promotion, the respondent number 1 and 2 are under a legal obligation to consider the same and pass appropriate orders. This exercise shall be undertaken and completed within a period of 2 months.
ಅಲ್ಲ ಪ್ರಮೋಷನ್ಗೆ ಹೆಂಗ್ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕೆ?
Allah, I have produced the material documents before the learned
You
single.
have no right for promotion, only right for consideration. ಯಾವಾಗ ಆಗುತ್ತೋ ಅವಾಗ ಆಗುತ್ತೆ ಅಷ್ಟೇ. Anyhow, you take notice, that's a different matter. Now, who's the answering respondent?
1 and 2.
1 and 2, my.
University, Gulbarga University. 3 is formal.
AG accepts notice for responding number
3.
ನಿಮ್ ಪ್ರಮೋಷನ್ ಆಸ್ ಪರ್ ರೂಲ್ಸ್ ಆಗುತ್ತೆ, ಕನ್ಸಿಡರ್ ಅಂತ ಹೆಂಗ್ ಆಗುತ್ತೆ? ಹಂಗ್ ನಾವು ಕೊಡಕ್ ಬರೋದೇ ಇಲ್ಲ ಅದು. ಅಲ್ಲ, ಹೌ ವಿ ಕ್ಯಾನ್ ಆಸ್ಕ್ ಆಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ರೈಟ್ ಪ್ರಮೋಟ್ ಮಾಡಿ ಅಂತ ಐ ಆಮ್ ಎಲಿಜಿಬಲ್.
I have produced the material document before the learned single judge. That is why direction is issued.
ಅಲ್ಲ, ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, consider- I submitted
ಪ್ರಮೋಷನ್
a-
ಮಾಡಿ ಇವಾಗ ಅಂತ.
The post is vacant. I submitted an application.
ದಟ್ಸ್ ನಾಟ್ ಯುವರ್ ರೈಟ್. ಇಟ್ಸ್ ಓನ್ಲಿ ಅ ರೈಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್. ಅವ್ರು ಯಾವಾಗ ಬೇಕಾದ್ರೂ ಅವಾಗ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ ಪ್ರಮೋಷನ್ ಅಂತ. ಸಪೋಸ್ ಪ್ರಮೋಟೆಡ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಇಲ್ಲ, I don't want to fill up.
They have to prepare the seniority list
ಅಲ್ಲ,
and thereafter
that is
DPC.
beside the point. Suppose there are vacancies. You can't issue a writ of
Yes,
mandamus,
yes, madam.
direct them to fill up the posts. There's no indefeasible right antar either for promotion. Anyhow, let us relist on. Yes. Yes. Yes, yes.
12 ಆಯ್ತಾ 12 ಆಗಿದೆ ಇದು 11 ಆಗಿದೆ
Additional SPP.
My lords. This is the case. This is the case wherein, my lords, the lordship may, it is a necessary to interfere in the lower court judgment as far as dying declaration is concerned.
ಒಂದ್ ನಿಮಿಷ.
Please.
ಕರ್ಸಿ ಫೋನ್ ಮಾಡಿ. ರಾಜೇಶ್ ಫೋನ್ ಮಾಡಿ.
Yes, I'll call. ಮಾಡ್ತಾ ಇದ್ದೀರಾ? I'll call.
Yes.
Portal number 4 ನಲ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್ ನಡೆದಿದೆ.
Total four, your lordships. He's arguing before total four, your lordships. He has just come from there.
We'll wait, let him come.
I'll inform.
On behalf of Rajesh Dodmani, my lordship, he is held up in portal number 4.
Yes, yes,
He is
sir.
on in this stand.
But let him start.
Yes, please.
Yes,
ನಿಮ್ಮ appeal ಅನ್ನು start ಮಾಡಿ.
ಹೌದು sir. This is a MC Biradar judgment, my lords. Exhibit P8, my lords.
ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ರಲ್ಲ ಅವರೇನಾ?
Sir,
ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ರು ಇವರು
ಆಮೇಲೆ ಹೋದ್ರು sir, ಆಮೇಲೆ he committed suicide.
Suicide, huh?
Yes.
same on the last day some
He trapped.
same person.
Yes. Last retirement day.
ತುಂಬಾ ಗಲಾಟೆ ಮಾಡ್ತಿದ್ವಿ ಕೋರ್ಟಲ್ಲಿ ಅಲ್ಲ ಹಿಂದೆ ಮುಂಚೆ ನಾವು ನೋಡ್ತಿದ್ವಿ ಸ್ವಲ್ಪ ಗಲಾಟೆ ಮನುಷ್ಯ.
ಸ್ವಲ್ಪ ವಾಯ್ಸ್ ಬಹಳ ರೇಜು, ಆಮೇಲೆ ಹಿಪೋಕ್ರಸಿ ಟೈಪ್. Justice Anchate was the principal judge on that time, my lords, in Bidar, and he was additional district judge. The first track court was there, my lords. By that time, he was trapped and
on the very last day.
last day.
Almost 100% acquittal. 100%.
100% acquittal. Wherein the dying declaration, every norms and conditions have been followed in this case, my lords.
100%. All the cases. No.
In all cases. A single case he has not convicted. Single, even in 302 cases, there were 5 eyewitnesses examined and they have fully supported, and it was a broad daylight murder then also. And that's what he became very famous. This is MC Biradar. So I'll come to the
Yes.
page number 4 of the paper book, that is exhibit P8, my lords, complaint, the deceased statement when it is recorded in Humnabad government hospital. In page number 4. Sir. Shall I read, my lords?
This is on 22/5/2012.
Yes, it is recorded. It was recorded on 22/5, but incident is set to have occurred on 21, sir. ನಾನು ಮೇಲೆ ನಮೂದು ಮಾಡಿದ ವೇಳೆ ಸೊ ಅಂಡ್ ಸೊ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ನಾನು ಮತ್ತು ನನ್ನ ಮಕ್ಕಳು, ಗಂಡ ಮತ್ತು ಮಾವನದ ಅಬ್ದುಲ್ ಸಲೀಂ ಸಾಬ್, ಅತ್ತೆ ಮೆಹಮೂದಾಬಿ ಎಲ್ಲರೂ ಕೂಡ ಒಟ್ಟಿಗೆ ವಾಸಿಸುತ್ತಿರುತ್ತೆ. ನನ್ನ ಗಂಡ ಒಂದು ದಾಬಾದಿಂದ ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡು ಮನೆಗೆ ಬಂದಲ್ಲಿ ಸರಾಯಿ ಕುಡಿದ ಆಮೇಲೆ ನನಗೆ ರಾಂಡ್ ಆಜ್ಕೊಂದ್ಸ ದಗಡ ಆಯ್ತಿ ಅಂತ ಹೊಲಸು ಮಾತುಗಳಿಂದ ಬೈದು ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದ. ನಮ್ಮ ಅತ್ತೆ ಮತ್ತು ಮಾವ ಸುಮ್ಮನೆ ಅವಳಿಗೆ ಯಾಕೆ ಹೊಡಿತಿ ಅಂತ ಕೇಳುತ್ತಿದ್ದಕ್ಕೆ ಅವರಿಗೂ ಕೂಡ ಬೈದು ನೂಕು ಹಾಕುತ್ತಿದ್ದ. ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರು ಹೇಳಿ ಬಂದ್ರೆ ಯಾರ ಮಾತನ್ನು ಕೇಳ್ತಿರ್ಲಿಲ್ಲ. The very incident she narrates in further in second paragraph. ಹೀಗಿರುವಲ್ಲಿ ದಿನಾಂಕ 21/5/2012 ಮಧ್ಯಾಹ್ನ 4 ಗಂಟೆಗೆ ಸುಮಾರಿಗೆ ಎಂದಿನಂತೆ ಸರಾಯಿ ಕುಡಿದ ಮೇಲಿನಲ್ಲಿ ಮನೆಗೆ ಬಂದು ನನಗೆ ರಣರಾಜ್ ಕೊಂಸ ದಗಡ್ ಆಯತ ಖಾನ ಕ್ಯೂ ನೈ ಪಕ್ಕಾಯ ಅಂತ ಬೈದು ಹೊಡೆಯಲು ಆರಂಭಿಸಿದನು. ಅಲ್ಲೇ ಇದ್ದ ನನ್ನ ಅತ್ತೆ ಮೆಹಮೂದಾಬಿ ಇವರು ಬಂದು ಬಿಡಿಸಿಕೊಳ್ಳುವಾಗ ಅವಳಿಗೂ ಕೂಡ ನೀನು ಮತ್ತು ನಿನ್ನ ಸೊಸೆ ಈ ಸೊಯನ್ಸ್ ಇಬ್ಬರು ಮಿಣ್ಗಾರ ಇಟ್ಟುಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಬೈದು ಅವಳಿಗೆ ಕೈಯಿಂದ ಹೊಡೆದು ಮನೆಯಿಂದ ಹೊರಗೆ ಓಡಿಸಿದನು. ನಂತರ ನನ್ನ ಕೂಡ ಹೊರಗೆ ಹೊರಟು ಹೋದ. ನಂತರ ಅಂದಾಜು ರಾತ್ರಿ 8:30 PM ಗಂಟೆಗೆ ನನ್ನ ಗಂಡ ಮರಳಿ ಮನೆಗೆ ಬಂದು ಮತ್ತೆ ನನ್ನ ಜೊತೆಗೆ ಜಗಳ ತೆಗೆದು ಕೈಯಿಂದ ಹೊಡೆಯಲು ಆರಂಭಿಸಿದನು. ಅಂಡ್ ಅಬ್ಯೂಸ್ ಇನ್ ಫಿಲ್ದಿ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಂತ ಬೈದು ಮನೆಯಲ್ಲಿಯೇ ಇದ್ದ ಸೀಮೆ ಎಣ್ಣೆ ಡಬ್ಬ ತೆಗೆದುಕೊಂಡು ಸೀಮೆ ಎಣ್ಣೆ ನನ್ನ ಮೈ ಮೇಲೆ ಸುರಿದು ಬೆಂಕಿ ಕಡ್ಡಿಗೇರಿ ನನ್ನ ಮೈಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದನು. ತ್ರಾಸಿನಿಂದ ಚೀರಾಡಿ ಒದ್ದಾಡುತ್ತಿರುವಾಗ ನನ್ನ ಗಂಡ ಮೈ ಮೇಲೆ ನೀರು ಹಾಕಿದನು. ನಂತರ ಓಡಿ ಹೋದನು. ನಾನು ನರಳುತ್ತಾ ಬಿದ್ದಿರುವಾಗ ನನ್ನ ಮಗಳಾದ ಶೈಸ್ತಾಯವಳು ನನ್ನ ತಂದೆ ತಾಯಿಯವರಿಗೆ ಫೋನ್ ಮಾಡಿ ಮುಖಾಂತರ ವಿಷಯ ತಿಳಿಸಿದ ಮೇರೆಗೆ ನನ್ನ ತಂದೆ ಮೊಹಮ್ಮದ್ ಇಸಾಮಿಯ ತಾಯಿ ಬೇಗಂಬಿ ಹಾಗೂ ನನ್ನ ಅಣ್ಣದರು ಕೂಡಲೇ ಮನೆಗೆ ಬಂದು so and so she is admitted. Only my submission would be, my lords, what it has been held in the what opined is the daughter of the deceased as well accused. She has not examined. Of course, it is true fact. Who informed to the her grandparents. That is there, my lords. ನನ್ನ ಗಂಡ ವಿನಾಕಾರಣ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ಕಿರುಕುಳ ನೀಡಿ ನನ್ನ ಮೈ ಮೇಲೆ ಸೀಮೆ ಎಣ್ಣೆ ಸುರಿ ಬೆಂಕಿ ಹಚ್ಚಲು ಮಾಡಿ ಪ್ರಯತ್ನಿಸಿದ್ದು. ಈ ಬಗ್ಗೆ ಗಂಡನ ವಿರುದ್ಧ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ವಿನಂತಿ. The same has been registered under section 498A and 307 of Indian Penal Code. And thereafter, my lords.
Just a minute, what is the age of this Shaista?
Shaista has not been
Not examined, not cited as a charge sheet witness. Huh?
not examined.
Whether she cited as a charge sheet witness?
I'll
Just see the-
come.
ನಮ್ಮ ಮಗಳಾದ ಅಲ್ವಾ? ಮಗಳಾದ.
ಮಗಳಾದ.
ಇಲ್ಲ, charge sheet witness ಹಾಕಿದ್ರು.
ಹಾಕಿಲ್ಲ ಸರ್. Shaista has not been cited.
Cited as a charge sheet.
Yes. Maybe I forgot. Yes,
So
ma'am.
she must be eyewitness.
Eyewitness to the incident.
Ah.
Eyewitness to the incident. That is the only.
Not cited as a charge sheet.
Yes, yes, my lord. That is the only thing. And thereafter, my lords, the
This mother-in-law Mahidubi, Mahmoudabi,
yes, my lord.
she turned hostile. Huh?
Hostile. And definitely, obviously,
She examined that?
she examined one. My lords, the PW1 accused father, and PW2 is a mother. PW, they both turned hostile.
PW5, mother of PW2.
PW2, my
Mahidubi
lords.
is the PW2.
Two. PW1 and 2 are the parents of the accused. 1 and 2.
Yes, yes, yes.
Ah,
So
and-
PW2 and this Shahista are the eyewitness.
Eyewitness to the incident.
So among them, Mahudabi turned hostile.
Ah.
Shahista not cited as a charge sheet.
Charge sheet, and she has not been examined.
Yes.
And PW3 is a Tashildar, is an important
Next
witness.
is Para.
Yes.
So based on this complaint, FIR registered.
Raised on 22/5/2012, my lords.
At about 6:15 AM.
AM, they received MLC and registered at 8:30 AM.
So 8:15 FIR registered.
Yes.
Yes.
And thereafter 10:30 dying declaration was recorded by the Tashildar on 22/5/2012.
Who admitted this? Who for this one shifted this injury to hospital?
Injured to hospital, they went over there and parents of the deceased.
It is forthcoming in the complaint that he also made an attempt to extinguish the fire ಅಂತ ಏನೋ ಇದು ಮಾಡಿದಾನಂತ. ನೀರು
ನಾನು ಚೀರಾಡುತ್ತಿದ್ದಾಗ ತಣ್ಣ ನೀರ್ ಚೆಲ್ಲಿ ಓಡಿ ಹೋದ ಅಂತ.
ಮತ್ತೆ ಓಡಿ ಹೋದ ಅಂತ.
ಮತ್ತೆ ಓಡಿ ಹೋದ. That is there in the complaint, my lords, in the exhibit PA.
So you intimated the Tashildar and
Tashildar came over there in presence of doctor.
ಯಾವ್ದು exhibit?
Exhibit dying declaration, exhibit P5 minutes. on 22/5/2012 at 10:30 AM.
Hmm.
The dying declaration was recorded by the Tahsildar before the doctor,
Hmm.
and 70% was the burn injuries.
Hmm. ಆಯ್ತು, ಏನ್ ಹೇಳಿದ್ದಾರೆ?
That's PW
Question and answer, format.
formats.
Hmm.
PW 3 minutes. In page number 49. Page number 49.
ಹಾ,
Lakshmi.
ನಿಮಗೆ ಕ್ವಶನ್ ನಂಬರ್ 4 ಗೆ ಬನ್ನಿ. ಯಾರು ಇಲ್ಲಿಗೆ ತಂದಿದ್ದಾರೆ ಮತ್ತು ಯಾವಾಗ? ನನ್ನ ತಂದೆ ತಾಯಿ ಹಾಗೂ ಅಣ್ಣ ತಮ್ಮಂದಿರುವ.
ಹೌದು.
ಹಾ,
ಹೌದು.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್,
The evidence of PW 3.
ಯಾರು ಹಲ್ಲೆ ಮಾಡಿದವರು? ನನ್ನ ಗಂಡ ಮೊಹಮ್ಮದ್ ಮದಾರ್.
Yes.
ಹ್ಮ್, ಆಯ್ತು. ನೆಕ್ಸ್ಟ್, ಸೀಮೆ ಎಣ್ಣೆ ಉಪಯೋಗಿಸುತ್ತಿರುತ್ತಾರೆ.
That has been ceased.
ಅಂಗಾಂಗಗಳ ಮೇಲೆ ತಣ್ಣೀರು ಹಾಕಿರುತ್ತಾನೆ.
ಹಾ.
ಈ ಬೆಂಕಿ ಹಚ್ಚಿದ್ದನ್ನು ನಾನು ಕಣ್ಣಿಂದ ನೋಡಿ ಗುರುತು, ನಂತರ ನನ್ನ ಸುಟ್ಟ ಶರೀರ ತಣ್ಣೀರು ಹಾಕಿರ್ತಾನೆ. ಸೀಮೆ ಎಣ್ಣೆ ಉಪಯೋಗಿಸ್ತಾರೆ ಅಂದರೆ ಸೀಮೆ ಎಣ್ಣೆ ನನ್ನ ಶರೀರ ಬೆಂಕಿ ಕಡ್ಡಿ ಗೀರಿ ಬೆಂಕಿ ಹಾಕಿರುತ್ತಾನೆ. ಹಾ, ಆಯ್ತು. ಕೊನೆಗೆ, ನೀವು ಈ ರೀತಿ ದುಃಖಪಾತ ಹೊಂದಲು ಕಾರಣವೇನು? ಗಂಡನು ಮದ್ಯ ಸೇವನೆ ಮಾಡಿ 25 4 ಗಂಟೆ ಸುಮಾರಿಗೆ this is the must be this is the contradiction, Mr. SPP.
Please.
ಮಧ್ಯಾಹ್ನ 4 ಗಂಟೆಗೆ ಅಂತ. ಸೊ ಇನ್ ಎಕ್ಸಿಬಿಟ್ PA 8:30 ಅಂತ ನೋಡಿ.
No, my lords. Madhyana 4 ಗಂಟೆ, the first instance wherein he came over there and.
Number 13.
Yes, I do agree. But my lords, drastic villagers.
ಕ್ವಶನ್ ನಂಬರ್ 13 ಆನ್ಸರ್ ಓದಿ. ನನ್ನ ಗಂಡನು.
Yes. ಮದ್ಯ ಸೇವನೆ ಮಾಡಿ ದಿನಾಂಕ 21/5/2012 ಮಧ್ಯಾಹ್ನ 4 ಸುಮಾರಿಗೆ ಮನೆಗೆ ಬಂದು ನನ್ನೊಂದಿಗೆ ವಿನಾಕಾರಣ ಜಗಳ ತೆಗೆದು ಕುಡಿದ ಅಮಲಿನಲ್ಲಿ ಅವಾಚ್ಯ ಶಬ್ದಗಳನ್ನು ಬಳಸುತ್ತಾ ಕೈಯಿಂದ ಒಡೆಬಡಿ ಮಾಡಿ ಕೆಳಗೆ ಉಳಿಸಿದ ನಂತರ ಸೀಮೆ ಎಣ್ಣೆ ಸುರಿದು ಕಡ್ಡಿಗೆ
ಒಡೆಬಡೆ ಮಾಡಿ ಕೆಳಗೆ ಉರುಳಿಸಿ ನಂತರ ನನ್ನ ಶರೀರದ ಮೇಲೆ ಸೀಮೆಯನ್ನು ಸುರಿದು ಬೆಂಕಿ ಕಡ್ಡಿಗೆ ನನಗೆ ಸುಟ್ಟಿರುತ್ತಾನೆ. And then there itself immediately.
So
exhibit P8.
Exhibit P8, that is, my lords, initially he came to the house at 4 PM. 4 PM, my lords.
ಮನೆಯಿಂದ ಹೊರಗಡೆ ಓಡಿಸಿದನು. ನಂತರ ನನ್ನ ಗಂಡನು ಕೂಡ ಹೊರಗೆ ಹೊರಟು ಹೋದನು. ನಂತರ ಅಂದಾಜು ರಾತ್ರಿ 8:30 PM ಗೆ ಮತ್ತೆ once again.
Yes.
Later.
Due to her severe injuries, she might have told something, my lords, but anyhow in exhibit P8, she has narrated that, my lords, at 4 PM, he had come to the house and assaulted her, quarreled with her. And thereafter, once again, in alcoholic position, he came over there and by 8:30, he poured kerosene and lit fire.
Exhibit P8, initial incident 4 PM.
4
Subsequently 8:30,
yes.
He set her ablaze.
Yes, set her.
Exhibit P5,
4
PM only.
4 PM.
The incident.
Yes.
The entire incident.
That is the only small discrepancy, I do agree. But anyhow, she has narrated pertaining to 4 PM. In exhibit P8 also it is there, my lords.
Tahsildar and officer present.
Yes. Tahsildar and officer and doctor were present, very much present, and doctor stated that she was in a fit condition to adduce her statement before the.
Very incident itself, within a gap of 2 hours, just 2 hours. See, morning about 8 o'clock, he registered, he recorded her statement.
Yes, my lord, 8:15.
Thereafter at
10:30.
10:30, she gave us different version. How it could be?
My lords, the severe pain she might have given instead of 8:30. Anyhow, she has stated 4 p.m. 8:00 ಮತ್ ನಂತರ ಅವ ಬಂದು ಮಾಡ್ದ ಅಂತ ಹೇಳೋದಕ್ಕಿಂತ she might have told that 4 p.m. he came over there in one verbal sentence. She might have told before the Tahsildar. So that can be appreciated, my lord, your lordship. And also, my lord, my fair submission would be, even it doesn't come under the purview of section 302, definitely it comes under section 304 part 1, my lords. Tannir erchida nantara. He had an intention, the mens rea comes. That is the only my submission would be.
We would have appreciated your argument. In
Yes,
the case of conviction.
Yeah,
not-
definitely.
This is a case against.
Yes,
acquittal,
my lords, yes, my lords, yes, my lords.
Case against acquittal. That is the, anyhow, let us see what is the evidence of parents.
And the parents, they are supported fully in chief examination, my lords. And so I would like to draw the essence of my lords on page number deceased mother, father.
PW 9 is the doctor who gave fitness certificate, huh?
Yes, my lords. PW9, doctor, the medical officer of Humanabad Government Hospital.
Tahsildar, PW 3.
3. And what happened, my lords, in page, my lords may come to page number 51. In chief examination, the same has been examined. The PW4 examined on 2/4/2013. On that day, they have supported the case of the prosecution in fully. After 2.5 months, my lords, that is on 26/6/2013, they are turned hostile. And in the cross-examination of PP, in page number 53, my lords, it is true to say that earlier I have given my evidence. However, I would like to say that while police forced myself to give such evidence, I have given such evidence. It is true to say that there is a compromise between myself and the accused. Both the parents of the deceased have stated the same origin.
So 1 over. 1 over the witness.
1 over the witness. 1 over the witness.
Both PW 4 and 5.
5
Mother,
minutes.
father and mother.
Mother.
She also said a
Same,
similar.
same verbatim. What PW4 stated.
How long she was survived?
5 days.
When she died on 27?
27/12/2012 minutes at 5 a.m.
Where, at,
at Gulbarga Government Hospital.
she shifted.
She shifted on 22nd after recording the dying declaration. She was shifted to Kalaburagi Hospital. That is Gulbarga Government Hospital.
Government hospital.
Yes.
So there she succumbed.
Yes. There she succumbed to injuries.
Death due to?
Burnage. Yes.
ಎಲ್ಲಿದೆ PM mark ಆಗಿದೆ?
ಆಗಿದೆ sir.
ಆಗಿದೆ.
PM has not been exhibited. Page number 32 is the opinion, minutes. Opinion as to cause of death. Cardio is typographical, lardio has been written. Is cardiorespiratory assert as a result of hypomic shock secondary to superficial to deep burns of the body of the extent of 70%. Time since death is 12 to 8 hours prior to PM.
Who wrote this exhibit P5? Tahsildar?
No, no, he has not.
Then
It is a person who has the person who has in exhibit B8.
written by this to exhibit P5 is written by the police.
Police has it. The person who had come to the hospital on that day after receiving the MLC. Sorry. The incident is said to have occurred in the accused house. Once again, section 106 of Evidence Act. And he has to. Incident is said to have occurred in the accused house. itself. And in 313, nothing has been narrated by the accused. If at all, as they have taken a defense, ಅಡಿಗೆ ಮಾಡುವಾಗ ಹತ್ತಿತ್ತು ಅಂತ ಹೇಳಿ, that could have been narrated in 313, nothing else.
Yes, Rajesh.
Lord, as per the exhibit P8, my lords, the daughter of the deceased was present in the house, namely Shaista. She is not cited as a witness, nor she is examined.
What was her age?
But that has not come. But they have not cited her as a witness, nor they have.
Minor, then why should they say?
But she would have been the best witness if even if a child.
The age. It's a child then. If she's a child,
True, my lords.
then.
Deceased age is itself 27 years. Deceased age.
But anyhow, it's stated that she only called.
Yes.
Shaista only called and
ಇಲ್ಲ ಇಲ್ಲ.
it's complaint ಅಲ್ಲಿ.
Exhibit P8.
ನಮ್ಮ ಮಗಳು called and Shaista.
ನನ್ನ ಮಗಳ
phone
ಶಾಯಿಸ್ತಾ.
ಮಾಡ್ಯಾಳ.
ಇವಳು
So can infer that she must be 8 or 10 years.
7 or 8 years.
7 or 8 at least.
That but all the witnesses have turned hostiles. Recovery of
One over the witness, how you can say after 2 months? 2 months they turned hostile, that too in the cross-examination. What is the position of law? The witness
one witness states that they had compromised. That has come in the
compromise, that is specifically suggested
That
and
is
admitted.
But must you not explain? It's in the house.
yes, that is not done in 313, my lords.
Some explanation how it could have happened. So that you can exculpate yourself.
Your conduct is very important. You ran away from the spot, you fled away from the spot immediately after the incident. Instead shifting her to hospital, Now, what is the discrepancy in the, this one, exhibit P5 and P8?
P5, my lords, the witness who has recorded it, PW3, the Tashildar, my lords, in his cross-examination, but it is elicited that, may I read his cross-examination, my lords?
Whose cross-examination?
The Tashidar's PW3's cross-examination. Page 50 of the paper book, my lords. Page 50, Mary. It is true that I have received exhibit P5 format from the police. I have not mentioned the identification of thumb impression, whether it is right hand or left hand. I also not mentioned the name of the person under the thumb impression. Exhibit P5 is not my handwriting. It is the handwriting of my clerk. I did not mention the name who wrote exhibit P5. It is true that exhibit P5 is written by the police. I cannot say the name of the police who wrote exhibit P5. Police also present then when I have recorded exhibit P5. The parents and the brother of Parveen also present when I have recorded exhibit P5. It is not true to suggest that have fabricated the dying declaration at the instance police and deposing falsely before the court. It is not true to suggest that police got prepared exhibit P5 and brought to my office. I have only signed on exhibit P5 and deposing falsely before the court. But this creates a doubt about the manner in which the dying declaration was recorded. But he admits that it is not he who has written the entire dying declaration. It is in the police format, my lords. That creates some doubt about the manner in which the dying declaration was recorded.
What is the procedure prescribed?
But the doctor would have to be present there. That the manner in which the dying declaration is doubtful, my lords. And the other witnesses, albeit the case is that they have been 1 hour, as my lords observed. But the fact remains that, my lords, it's an appeal against acquittal. And the
What is the procedure prescribed to record a dying declaration according to?
the presence of the doctor is a must at the but the PW9, my lords. But it is not identified. He doesn't identify whether it is a thumb impression of the right hand or left hand. He admits that it was his clerk who has recorded, who has written it. That appears to be, my lords, it creates a doubt about the manner of the very inception of the dying declaration itself. It's a clear admission by the PW3. When the very basis for that, my lords, is shaky, my lords, that my lords may not be believed upon. That is what the trial court has rightly done. And as my lords, my lord, may I just pass on compilation of judgment, my lords. So far as 106, I'm sorry, I could not mark it. I just mentioned the page numbers, my lord, as I read it out.
What is your explanation? 106 NL. What is your?
No, it was for the prosecution to establish it beyond reasonable doubt. As my lord says, very recently held in this judgment, my lords, it was for the prosecution.
ನಮ್ದಿದ್ರೆ ಹೇಳ್ಬೇಡಿ ಅದು ಕಂಟೆಂಪ್ರೇನಿಯಸ್ ಇದ್ರೆ ನಮ್ಗೆ ಇಲ್ಲೇ ಇದೆ ಅದು something else you say.
Lord, I have made a compilation, my lords. May I just pass on?
Copy ಇದೆ sir. ಇದ್ರೆ ಕೊಡಿ ಇಲ್ಲಿ. First, my lords, to take page 31, my lords. Page 31. Para 49. Page 30 in the para, what is prima facie case? Foundational facts in the context of section 106 of Evidence Act. The Latin expression prima facie means at first sight, at the first view, or based on the first impression. According to Webster's Third International Dictionary, prima facie case means a case established by prima facie evidence, which in turns evidence sufficient in law to raise a presumption of fact or establish a fact in the question unless rebutted. In both civil and criminal law, the term is used to denote that upon initial examination, a legal claim has sufficient evidence to proceed to trial or a judgment. In most legal proceedings, one party, typically the plaintiff or the prosecutor, has a burden of proof which requires them to present prima facie evidence for each element of the case or charges against the defendant. If they cannot present prima facie evidence, the initial claim may be dismissed without any need for a response by other parties. Section 106 of the Evidence Act would apply to cases where the prosecution could be said to have succeeded in proving facts from which a reasonable inference can be drawn regarding the guilt of the accused. In this present case, my lord, spot the witness to the spot Panchanama, PW 6 and PW my lords, 9. PW 10, PW 6 and 10, who are the spot punchers, have turned hostile to the prosecution case, my lord. The can in which kerosene was supposed to be there was recovered in the spot Panchanama. That is not proved. The witness to that spot Panchanama have turned hostile, my lord. May I request
PW 6 has supported the case of the prosecution. PW 6,
What he supported?
he supported.
PW 10 or turned hostile?
Yes, my lords.
He's being treated as hostile, cross-examined the prosecutor, my lords. Muhammad Azam, PW.
To some extent, some extent.
For as recovery of MO5.
Prima facie, the evidence of PW 4, 5, 4 and 5, since they supported in the chief examination, prima facie, yes, prosecution, prima facie proved.
That, my lords, may I request my lords to take page 71 of the compilation, my lord. The position as regards the interference against acquittal appeal. Page 24. I'm sorry, page 71, para 24, my lords, the compilation. May I read, my lords?
Yes.
We may firstly discuss the position of law regarding the scope of intervention in a criminal appeal. For that is the foundation of this challenge. It is the cardinal principle of criminal jurisprudence that there is a presumption of innocence in favor of the accused unless proved guilty. The presumption continues at all stages of the trial and finally culminates into a fact when the case ends in acquittal. The presumption of innocence gets concretized when the case ends in acquittal. It is so because once the trial court, on appreciation of evidence on record, finds that the accused was not guilty, the presumption gets strengthened and a higher threshold is expected to rebut the same in appeal. No doubt an order of acquittal is open to appeal and there is no quarrel about that. It is also beyond doubt
that in the excess of appellate powers, there is no inhibition on the High Court or to reappreciate or revisit the evidence on record. However, the power of the High Court to reappreciate the evidence is a qualified power especially when the order under challenge is of acquittal. The first and foremost question is to be asked whether the trial court thoroughly appreciated the evidence on record and give due consideration to all material pieces of evidence. The second point for consideration is whether the finding of the trial court is illegal or affected by an error of law or fact. If not, the third consideration is whether the view taken by the court is a fairly possible view. A decision of acquittal is not meant to be reversed on a mere difference of opinion. What is required is an illegality or perversity. It may be noted that possibility of two views in a criminal case is not an extraordinary phenomenon. The two views theory has been judicially recognized by the courts, and it comes into play when the appreciation of evidence results in two equally plausible views. However, the controversy is to be resolved in favor of the accused. For the very existence of an equally plausible view in favor of innocence of the accused is in itself a reasonable doubt in the case of prosecution. Moreover, it reinforces the presumption of innocence, and therefore, when two views are possible, following one in favor of the innocence of the accused is the safest course of action. That apart, my lord, the respondent and the deceased together had 6 children. That has come in the evidence of cross-examination of PW4.
6 children.
5 daughters, 1 son.
The
That-
deceased.
Deceased, between deceased and appellant out of their marriage.
Huh.
That is 5 daughters, 1 son. And okay.
27 years old. Age is about 27 alone.
Yes, ma'am. 27, it has been written.
Cross-examination ಬಂದಿದೆ ಅದು.
Huh. 6 daughters, 6 children.
5 daughters, 1 son. And
Hmm.
12 years
Now
ago,
they are
marriage
under the care and custody of. Now they are under the care and custody.
of the respondent, my lords.
Respondent.
In fact, on warrant, he was secured before this court.
Hmm.
The daughter was with him. On warrant, he was secured with this honorable court. At that point of time, I filed an recalling application of the warrant and sought for bail in this appeal. His daughter and other family members were present with him. Thereafter, he had approached the legal service authority, my lords, through which I was appointed in this case. But I have seen them, my lords, he was present with his daughter and other people. Lords, kindly be permitted to file citations. Rajendra versus State of Maharashtra, wherein they have the dying declaration, sole dying declaration is merely sufficient to convict.
How year is it?
The Rajendra versus State of Maharashtra. In criminal appeal number
Of the year?
2281 of 2011, decided on May 15, 2024. Para 7, my lords, the same story. In para 7, that is a dying declaration recorded by the special executive magistrate. Here is the, as that was not proved, insofar exhibit P15 dying declaration is concerned, he submits that PW told the doctor had given the time of recording the dying declaration as 11:45 PM. And here is PW9 doctor who treated first aid the deceased, and she stated that she was very much present. The doctor was very present by that time. And also the opinion of the trial judges, my lord, there is a delay in recording the dying declaration, but the case has been registered at 8:15 AM. The dying declaration was recorded on the same day at 10:30 PM, only after 2 hours. The question of delay on that particular day does not arise. Hospital 12:30. Hospital 12:30.
It's a case of against conviction, I think. Against conviction.
Yes, whatever it means. The question would be, my lords, the dying, whether at what extent dying declaration is to be believed. And in environmentally, the
2000
apex court has discussed in para 21, 23, 24, 25, 26, and 27, my lords. And also the apex court has held in para 27 in Kushal Rao versus State of Bombay.
The apex court in the case of that Irfan Naka versus UP.
My lords.
Criminal appeal on ನೋಡಿಬಿಡಿ madam. Irfan Naka versus UP. Then summarizes the guidelines of dying declaration once again.
My lords.
So it's, in that case, it is, but the apex court held that dying declaration is a substantive piece of evidence, provided the must be truthful, voluntary and truthful. Some corroboration is required. Some corroboration required.
And all the norms which have been led by the apex court for recording the dying declaration, my lord, she is a in fit state of mind, and she was able to give a statement. And also, what I submitted, that a dying man cannot lie. So, my lords, no one would meet the maker with a lie in his own mouth. Of course, I do agree, my lords. There are 6 children.
Now, after the incident caused in the 2013,
12, sir. 12.
2012. After 12 years,
Yes, my lords.
case of acquittal, not like conviction, case of acquittal.
And one more criteria to state is the judgment is.
What is that? Yes. Did you observe?
Apparently it shows that, my lords, the cross-examination time has been given 2.5 months. This fortified the thing, my lords. And in moreover, our police makes lacunas and lacunas. That is also faulty investigation. The very child should have been made arraigned as a best charge sheet witness. Yes, ma'am. Best witness, ma'am. Even rather comparing to dying declaration, if she would have supported the case, the thing would have been different. I do agree with her. But whatever my effort has to be, sad and
Status. The state has preferred this appeal against the judgment dated 31st January 2014, passed in SC number 16 of 2013 by the additional district and session judge at Bidar, wherein the learned session judge, hereinafter learned session judge, wherein the learned session judge has acquitted the accused for the charges leveled against him, that is for the offense 498A and 302 of IPC. Next one. The abridged facts of the prosecution case are as follows. The respondent slash accused is husband of the deceased Parveen Sultan in this case, their marriage, Sultan, and ever since from the date of their marriage, the accused was subjected her to cruelty and cruelty. On 21. So married, 5 years ago in Badri.
12 years ago.
In this case, and they begot 6 children out of the wedlock, full stop. The accused ever since full stop. The accused ever since better. The accused used to harass the deceased both physically and mentally by consuming alcohol, and used to assault her on daily basis, full stop. On this scenario, on this background, backdrop, on 21/5/2012 at about 4 p.m., the accused came to the house and picked up a quarrel picked up a rope with the deceased, and he assaulted her. Full stop. However, his mother, that is the mother-in-law of the deceased, one Mahimudabi, bracketally PW2 made an attempt to rescue her, the accused, for which the accused also assaulted PW2, full stop, and left the house, full stop. They subsequently at about 8:30 p.m., the accused came to the house and once again picked up a rope with the deceased and by abusing her in filthy language, poured kerosene on her person and set her ablaze. Set her ablaze. Full stop. Thereafter, he also made an attempt to extinguish the fire by pouring water. Water. Full stop. The said aspect was, the said aspect was full stop. Pouring, water. Full. Subsequently, he fled away from the spot. From the spot. Full stop. The said incident was informed to the parents of the deceased, that is PW4 and PW5, by the daughter of accused and deceased, one Shahista. Thereby, the daughters of the parents of the deceased rushed to the spot and shifted their daughter to government hospital at Humnabad. Government hospital, Humnabad. Full stop. On the Humnabad. On the following day, that is on 22/5/2012, based on the MLC received from the hospital, from Humnabad Government Hospital, PW
Millets.
Arrow.
PW8, CW20 minutes.
PW8, the then ASI visited the hospital and recorded the statement of injured Parvina and Parvina as per exhibit P8, full stop, exhibit P8, full stop. On the strength of exhibit P8, the PW8 registered the case in crime number 67 of 2012 against the accused for the offence punishable under section 498A, 307 of IPC. 307 of IPC. Full stop. IPC as per exhibit P9. Exhibit P9. Full stop. The exhibit P9. Full stop. Subsequently, the based on the request made by PW8, the Tahsildar of Humnabad, visited the hospital, visited the government hospital, Humnabad, and also recorded the dying declaration of the injured as per exhibit P5. As per exhibit P5.
Yes.
Full stop. During the course of recording the exhibit P5, the doctor PW9 PW9 was present and issued the fitness certificate of the injured to depose such statement as per exhibit P5. Full stop. P5. Next. Thereafter, the injured Parvina, shifted to government hospital Kalaburagi for higher treatment. And higher treatment.
On 22/5/2000.
And on 22/5/2012, shifted, and on 27/5/2012,
At 5 AM.
at about 5 AM, the injured succumbed to the succumbed to the injuries in the said hospital,
Yes.
said hospital. Thereafter, said hospital. Thereafter, the PW, thereafter, PW, PW 8, PW8 sent a requisition, requisition to the jurisdictional magistrate to invoke section 302 of IPC
Yes.
in crime number
67 of
67 of 2015.
12.
67 of 2012. Accordingly, the permission, permission accorded by the magistrate and section 302 invoked, full stop. For thereafter, the investigation officer, that is PW9, PW 19, PW 19, 19 conducted the investigation, by apprehending the accused, so also drawing the relevant hazards, and by recording the statement of material, statement of the witnesses, for sure, witnesses. After full stop. Thereafter, the PW20 by obtaining the FSL report, concluded the investigation and laid the charge sheet against the accused, for the offence 498 and 302 of IPC before the committal court. Also, after committal of the case before the session court, the accused of the learned session judge framed the charges for the said offences, for the aforementioned offences, and read over the same to the accused, the same denied by the accused, and he claimed to be tried. Full stop. The next, in order to prove the charges leveled against the accused, the prosecution before the trial, before the session court, the prosecution in total examined 20 witnesses, so also got marked 22 documents, and got identified 5 material objects. Full stop. Post assessment of the oral and documentary evidence, next para. Post oral and documentary evidence, the learned session judge acquitted the accused from the charges leveled against him. The said judgment is challenged in this appeal by the state. We have heard Shri Patil, learned additional SPP for the state. So also Shri Rajesh Dodamani for the respondent accused. The primary contention of the learned SPP, learned additional SPP, that the learned session judge, totally failed to appreciate the evidence available on record and acquitted the accused from the charges leveled against him, which is not sustainable under either on law or on facts of the case. Full stop. According to him, the judgment and the judgment challenged in this appeal totally suffers from perversity and illegality. Full stop. He would submit that the prosecution has placed sufficient evidence and documents to prove the charges leveled against the accused. PW full stop. Immediately after the incident, PW8, the ASI recorded the dying declaration of the, recorded the statement of the statement of the injured as per Exhibit P8, wherein she clearly narrated the incident, that the accused is the perpetrator of the crime. Full stop. To substantiate the contents of Exhibit P8, the prosecution also placed the Exhibit P5, that is the dying declaration recorded by the Taluk Executive Magistrate PW3 in the presence of the duty doctor PW9. Full stop. Exhibit P, as per Exhibit P5. The Exhibit P5 clearly depicts that the injured was in a fit condition to give her statement. The Dr. PW9 doctor made such endorsement on Exhibit P5. Full stop. In P5. Moreover, Exhibit P5 also contains the signature of the injured, full stop. In the injured. Moreover, the injured survived for another, moreover, the injured survived for a period of 5 days thereafter. In such circumstance, there is no reason to discard the veracity of Exhibit P5, full stop. P5 by enunciating his submission, he contends that the parents of the deceased, that is PW 4 and 5, have categorically supported the case of prosecution in their chief examination.
Yes.
However, after 2 months, the accused, the defense cross-examined defense cross-examined, and at that point of time, they turned hostile. Full stop. This clearly shows that the accused won over the witnesses, these witnesses. Full stop. In such circumstance, their testimony cannot be discarded. Full stop. He would also contend that the prosecution also proved the recovery of the kerosene can and the recovery of the
Kerosene dabba, bottle, matchbox.
recovery of the spot mahazar exhibit, exhibit P6 by the evidence of by examining PW6
Were supported.
and PW10, wherein the kerosene can and other articles used for the commission of the crime were seized in the house. Full stop. House.
MO 3 to 5 minutes.
That is MO 3 to 5. He would also contend that since the incident passed in the house of the accused, the accused is duty bound to explain the circumstance, explain the reason / circumstance for the death of the deceased. Full stop. Hence, full stop. Disease. Hence, the learned session judge totally erred while acquitting the accused without appreciating these relevant facts, relevant evidence and the documents placed by the prosecution. Full stop. With this submission, he prays to allow the appeal. He also relied on judgment. Per contra, Shri Rajesh Dodamani, then counsel for the respondent accused, would submit that the learned session judge, after examining the entire evidence and materials placed before him, at length, passed a well-reasoned judgment which does not call for any interference. Full stop. You would further contend that the content that on perusal of the contents of exhibit, on perusal of the contents of exhibit P5 and exhibit P8, the initial statement given by the deceased. So also the subsequent dying declaration recorded by the Tashildar, that is exhibit P5, there is a clear, there is a clear difference in respect of the very time of the incident, According to exhibit P8, the incident was caused at about 4 p.m. on
8:30.
uh,
8:30.
at about
4 and 8:30 p.m.
4 and at about 8:30.
8:30 p.m.
8:30 p.m. on 21/5/2012. However, as per exhibit P5, in exhibit P5, it is stated that the incident was initially caused. The incident was caused at about 4:30. 4 p.m. 4 p.m. 4 p.m. 4 p.m. 4 p.m. Nevertheless, the Tashil in the during the course of cross-examination of the Tashildar PW3 has categorically stated that, the exhibit P5 dying declaration was recorded by his
Clerk.
assistant, his clerk, and he has not mentioned the name of the name of the deceased, name of the deceased, or identified the thumb impression
whether it is right or
of
not.
the deceased affixed on exhibit P5.
Yes.
Exhibit P5. Full stop. Exhibit P5. The exhibit P5. As such, there is a clear doubt occurs in the genuineness of in the veracity of exhibit P5. P5 truthfulness of exhibit P5. Full stop. You would also contend that the PW4/5, that is the parents, and PW11, the brother, and PW13, the one more witness, the PW13, the another relative of deceased, all are turned hostile to the prosecution case, Full stop. PW4 and 5 even explained the circumstance for the deceased sustaining injuries that she sustained the same due to accidental fire. In such circumstance, there is no reason to in such circumstance, the prosecution has totally failed to place any believable evidence to convict the accused. Since both the dying declaration as well as the oral testimony of the material witness are totally contradictory and not trustworthy to believe. Full stop. Believe. In such circumstance, the learned session judge rightly rejected. Session judge rightly appreciated those facts and acquitted the accused from the charges leveled against him. Full stop. Moreover, this appeal being the against the acquittal order, as per the settled position of law, the interference in the acquittal order only calls for if the view taken by the trial court while does not call for, if the view taken by the trial court while acquitting an accused can be a reasonable view, reasonable view, full stop. And with this reasonable view, with these grounds, with this submission, he prays to dismiss the appeal. Full stop. On careful, full stop. Having heard the learned counsel for the, we have given our anxious consideration both on the argument advanced by the learned counsel for the respective parties. So also the documents, the evidence and other materials placed before us, the only point that would arise for our consideration is whether the learned session, whether the judgment under this appeal suffers from any perversity or illegality, and the learned session judge is justified in acquitting the accused for the charges leveled against him. Full stop. The next, on careful perusal of the entire evidence on record, as per the record, to prove the homicidal death of the deceased, the prosecution predominantly relied the exhibit P7 inquest Panchanama conducted on the corpus of the deceased as per exhibit P7, exhibit P7, exhibit P7, the P7, further P7, further which depicts that the deceased was sustained burn injuries, full stop. Further burn injury. Further, the prosecution also placed the evidence, also relied on the evidence of PW9, the doctor who treated the injured in
First aid.
Given the first treatment to the injured in the government hospital at Humnabad, government hospital, Humnabad, full stop. Humnabad, full stop. The Tahsildar, full stop. Humnabad. So also the evidence of the Tahsildar PW3, who recorded the dying declaration, stating that the injured was sustained burn injuries.
Yes.
Burn injuries, full stop. Though the prosecution failed to place the post-mortem report conducted, failed to examine the doctor who conducted the autopsy on the dead body, and to place the post-mortem report by on careful perusal of the above evidence, perusal of the above materials, it could be concluded that the death of the deceased was caused due to burn injuries and in unnatural circumstance in the house, in the matrimonial house, full stop, matrimonial house. Next, in order to connect the accused for the said death, death of the deceased, the prosecution relied on the evidence of PW4 and PW5, that is the parents of the deceased. So also on exhibit P8, that is the statement given by the injured herself given by the deceased herself initially in the hospital to PW8, the then ASI of respondent police, and also exhibit P5, the dying declaration recorded by the Tahsildar PW3, full stop. On perusal of the evidence of PW4 and 5, both these witnesses have supported the case of prosecution during the chief examination. However, during the course of cross-examination, both these witnesses have totally given a go by to the prosecution case, full stop. Prosecution case. Further, they also explain further in their cross-examination, they also explained the circumstance how their daughter sustained the burn injuries, full stop. According to them, due to accidental fire, she sustained the said burn injuries, full stop, injuries. Nevertheless, the PW 11, the brother of the deceased, also totally turned hostile to the prosecution case. The other relative, PW 13, also turned hostile to the prosecution case, full stop, prosecution case. In such circumstance, the evidence of this PW 4 and 5, not trustworthy to the testimony of PW 4 and 5, not trustworthy to rely to prove the charges leveled against the accused, full stop. They full stop. Further on careful perusal of the contents of exhibit P8 and P5, the declarations made by the deceased, as rightly contended by the learned counsel for the respondent, there is a clear difference in respect of the clear contradiction in respect of the contradiction in respect of the time of the incident. According to time of the incident, exhibit P8 depicts that the incident on 21/5/2012, at about 4 p.m. the accused came to the house by consuming alcohol, and he picked up a row with the deceased, and thereafter he assaulted to her, so also his mother, that is the mother-in-law of deceased PW2, and left the house. Thereafter, at about 8:30 p.m., he came to the house and once again picked up a row and poured kerosene on her person and set her ablaze. Whereas exhibit P5, the dying declaration recorded by PW2 depicts PW3 depicts that the incident was caused at about 4 p.m. on 21/5/2012. For sure, 2012. This material contradiction in respect of the time of the incident, creates a doubt in the doubt in exhibit. Creates a doubt in the creates a doubt in the mind of this court in respect of the contents of, in regard to the contents of exhibit P8 and 5. Exhibit P8 and 5. And nevertheless, as rightly pointed out by learned counsel for the respondent, the said dying declaration, the PW2 in his cross-examination admitted that the same was recorded by his clerk. He was neither cited as a charge sheet witness nor examined before the court. Full stop. Before the court. PW3 also failed to state, they failed to identify they fail to identify the thumb of deceased, thumb of the deceased, so also to mention her name,
Yes.
name in the
It is PW3, my lords, dictated PW2.
PW3, madam. Identify the thumb of deceased, so also to mention her name in exhibit P5, exhibit P5, exhibit P5, full stop, P5. The P5, full stop, in exhibit P5. No doubt, the said statement recorded in the presence of the Dr. PW, Dr.
Nine.
PW9, PW9. However, the very incident itself, the very incident itself, however, the timing of the incident itself is contrary to the first statement deposed by the victim, deceased, comma, the without deceased, comma, it is hard to rely on exhibit
P8.
P8 solely without any such corroborative piece of evidence, full stop. The Honorable Apex Court, in the case of Irfan alias Naka versus the state of Uttar Pradesh, sixth other reported, Uttar Pradesh, in criminal appeal number 825-826 of 2022, dated 23/8/2023, held in paragraph 62, as under, madam, 62 as under, full stop. Full stop. The dictum laid down by the Honorable Apex Court in the above judgment established that though dying declaration is a substantive piece of evidence to be relied, provided it is proved that the same was voluntary and truthful, and the victim was in a fit state of mind. It is just not enough for the court to say that the dying declaration is reliable, as the accused is named in the dying declaration as assailant, full stop. The assailant, full stop. The assailant in the full stop. ನೀವು ಯಾವ್ದು ಕೊಟ್ರಿ ಯಾವ್ದು?
Judgment of the Apex Court.
Page number?
Page number, my lords, 71. Number
Is
7.
in respect of acquittal, alva?
Yes.
Acquittal, full stop. The full stop. As far as the full stop, as far as full stop. Hence, by applying the principle, by applying the law summarized by the Honorable Apex Court in the above judgment to the fact and circumstance of this case, fact and evidence of this case, as discussed supra, we are of the view that the exhibit P3 and exhibit P8, exhibit P5 and exhibit P8 cannot be relied, cannot solely be relied to convict the accused, to prove the charges leveled against the accused. Full stop. The contention raised by the learned counsel for the argument advanced by the learned SPP that the incident was passed in the house of the accused, and he is duty bound to explain the circumstance. If he has not committed the incident, who else has been committed who else has been cause for such incident. Full stop. No incident as contemplated under section
313.
106.
106. 106.
Indian Evidence Act, full stop. Evidence Act. However, the Honorable Apex Court in the case of
Anis versus
uh,
Anis versus the state government of NCT.
Anis versus state of
NCT.
first judgment adu.
Hೌದು, page 31.
Anis versus state government of NCT in criminal appeal number 437 of 2015, held that section 106 of Indian Evidence Act would apply to cases where the prosecution could be said to have succeeded in proving facts from which a reasonable inference can be drawn regarding the guilt of the accused. Full stop. The prosecution is duty bound to establish prima facie case against the accused, and then only such burden shifts on the accused to explain the adverse circumstance. Full stop. In para
49.
para 49 of the judgment, para 49 of the judgment, comma, held as under 49 matra alva?
49 in the up till 51 would be relevant.
49
in the
49 to 51 na?
yes.
49, 51, madam.
And the other judgment of the apex court is also extracted in the
49 to 51.
yes.
Full stop. In such circumstance, full stop. In such circumstance, comma, see in the case on hand, since the prosecution failed to place any such prima facie evidence,
Yes.
prima facie evidence and documents to prove, to discharge the initial burden, as the PW, as the parents of the deceased, the PW 3 and 4, PW 4 and 5 have turned hostile to the prosecution case, comma, we are of the view that the prosecution failed to discharge such a burden, such initial burden. Full stop. Further, this appeal arising, this being an appeal against acquittal, comma, the Honorable Apex Court in the case of HR Sundar and others versus State of Karnataka reported in 2023, Volume 9, SCC 581, summarized the principles to exercise the power by the appellate court to interfere in the order of acquittal in paragraph 9 as under. Further, the Honorable Apex Court in the case of Mallappa and others versus State of Karnataka reported in 2024, Volume 3, SCC 544, while once again summarizes the principle in dealing with the appeal against acquittal in paragraph number 42, as under, full stop, as under. Hence, full stop, by applying the above principles, applying the above guidelines by the Honorable Apex Court in the judgments, comma, and also on careful perusal of the entire evidence placed by the prosecution in the instant case, comma, we are of the considered view that the prosecution has failed to place sufficient evidence to prove the charges leveled against accused beyond reasonable doubt. in full shop. In that view of the matter, we decline to interfere in the judgment passed by the session court. Accordingly, we answer the point raised above in the affirmative and proceed to pass the following order. The criminal appeal is dismissed, being devoid of merits.
Much.
Your Lordships.
ಏನಪ್ಪ? ಹ? ಇಟ್ಟೆ
What up, sir? What up, sir?
ಸರ್ ಕೇಳ್ತಾ ಇರೋದಾ?
ಕೇಳ್ತಾ ಇದೆ ಮೇಡಮ್.
ಸರಿ ಸರ್.
ಮೇಡಮ್ ನಾವು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಿದ್ಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಇಂದ ಏನು ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಸರ್
ಹಾ, ಈಗ ಕಾಣಿಸ್ತಾ ಇದೆ. ಹಾ, ಸರಿ. ಫಸ್ಟ್ ಯಾವ್ದಮ್ಮ ಇದು ಬ್ಯಾಂಗ್ಳೂರ್ ಬೆಂಚ್ ಇದಕ್ಕೆ ಹೋಗ್ತೀರಮ್ಮ?
ಸರ್ ಅದು ಒಂದೇ ಇರೋದು ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್.
ಅದೇ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ತಾನೇ ಕೂಗೋದು ಫಸ್ಟ್.
ಹಾ ಸರ್, ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ. ಇಲ್ಲ ಇದು ಇಲ್ಲ ಶರ್ಮಿ.
ಮುಂದಿದೆಯಲ್ಲ
Of order, serial number 1, Sri Rajashekar.
For the petitioner. Accordingly, both the writ petitions are rejected.
Please.
Grateful.
Non-compliance of office objection, first time, serial number 2, KV Satish Chandra. KV Satish Chandra, serial number 2.
Pass over. Yes, Tejesh, you are appearing here.
Yes,
for
my
the-
lord, I am appearing in this matter, my lord. I think the office objection, my lord, they have to comply. The non-compliance office objection is posted. I'll have, but I'll accept notice, my lord, in this matter.
Correct, it's a bail matter.
Please,
So I'll pass over. Let us see what the case is.
please, my lord.
Instructions ಇದೆಯಾ ಇದರಲ್ಲಿ?
No, my lord, that is what I have to get the records from. Any short accommodation, my lord, I'll assist the court.
I'll give it, but let him mark his presence. I'll pass
Please,
over.
please, very well, my lord. Please, my lord.
Frequently accommodate a short date.
Please, my lord.
This is the first time it's coming, is it?
Yes, my lord, first time it is coming up.
Now he's in custody since how long?
The present petitioner, my lord, is accused number 7, my lord.
He's been in custody for 5 years, 8 months, as per para 10.
Please, my lord, that is what they have mentioned.
Shall we give a short date? By then you complete your instructions.
Please, my lord, I'll complete my instructions, my lord. For the offense 302, my lord, life is there. 307 and 302, life imprisonment, my lord. Anyhow, my lord, short accommodation, Monday or Tuesday, next week, any date which is convenient to this honorable court, my lord. I will.
Whenever I sit single, I'll relist this.
Please, my lord.
But you must only appear one.
Please, my lord.
And you must complete your instruction because.
Please, please, my lord, because I'll also secure the report from the IO, the antecedents report with respect to the present petitioner, my lord. Any criminal case or any other cases where he is facing charges and all. I'll get all the instructions, my lord, by that time.
Lord Counsel Sri Tejesh accepts notice on behalf for the state. No representation on behalf of the petitioner is granted. Petitioner is granted time for compliance with office objection. Necessary instructions to be completed by the respondent state, as it is the first date on which the matter is listed, and in light of time sought for by counsel for the state. Instructions in light of special bench requires to be constituted, as the date would be intimated by the registry.
Please.
You complete it by the next day.
Please, please.
Serial number 3, Gautama Devi C. Ullad.
I am for the respondent, your lordship, for number 2.
Appear for petitioner, my lord.
State was required to complete.
Respondent state in this matter.
Respondent state was required to file their statement of objections.
Please, my lords, pray for a short accommodation, my lords. Have been instructed to appear today. 2 weeks accommodation, we will file our version, my lords, please.
Correct, because it's part heard, I don't want to retain it by the
As
next
a
day.
last opportunity, my lords, please.
Yes, I'd request on behalf of Additional Advocate General appearing for the state, who submits that statement of objections would be filed by the next date. Matter is adjourned by 2 weeks. Yes. I will
Much
assign a
obliged.
date. I'll assign a date, but get ready by the next date.
Please, please. Obliged.
Fourth, party in person, Srimati Meera Patankar.
I appear for the, I appear for the respondent, my lord.
Yes.
My lords may recollect, this is the matter where we were trying to, my lord, settle the matter.
Yes.
My lord, I contacted Srikara, my lord. Unfortunately, the party has taken the file back from him. I think they may engage somebody else, my lord. My lords may have it after 2 weeks because we had some discussions and then the party has taken the file back from Srikara, my lord. That is what Mr. Srikar told me, my lord.
No representation on behalf of the petitioner. Learned counsel appearing for the respondent submits that some efforts were made to explore possibility of settlement, but submits that further time is required. Relist week after next.
Yes, very well, my lord. Grateful.
Number 5, Chennai Gowda C.
I appear for respondent number 5, my lords.
Yes.
Appearing for respondent 4, my lord.
Yes.
Lords, the matter is with respect to where the respondent number institution collected the excess fees and this honorable court directed us to for repayment of the same, my lords. My lords, as of today, 8 students have collected the excess amount. My lords. Since we received the said documents yesterday, we were not. So, Malaj, we communicated with the other students also since the PG NEET examination is going on. They did not approach the institution, Malaj. As of today, we have paid to 8 student, Malaj. We will place it on record, Malaj. Week time maybe.
But then complete your instructions, the disposed of matter, isn't it?
Sorry, my lord's voice is not audible.
It's a disposed of matter. So complete.
It is, my lord.
So I'll have it once again after 2 weeks. You complete whatever is required. Otherwise, they're seeking for revival of the petition.
Please, Malaj, the students are not approaching to the institution because the PG NEET examination is going on, Malaj. As of today, we have paid to 8 student, Malaj. We will file the memo with respect to that, Malaj.
Learned counsel appearing for respondent number
5, Malaj.
5 submits that the refund of excess fee.
Please, Malaj.
Has been made insofar as 8 students are
8
concerned.
students, Malaj.
And necessary memo would be filed to that effect. And as regards other students, necessary steps would be taken.
Please.
Relist after 2 weeks.
Please, Malaj.
Further hearing. Number 6, Sunil MV.
Appear for respondent, my lord.
Just 1 minute. Just 1 minute, madam. I'll take up the next matter and come back to this.
Please.
Next.
Till number 7, Saravana S.
No representation on behalf of the petitioner. Matter is adjourned. As the matter relates to single bench roster, special bench would have to be constituted. on a day other than on which the division bench sits. Accordingly, matter is adjourned.
Seat number 6, Sunil MV.
Yes.
No, I do not want to repeat the argument which I have already done, but I do not want to. Only want to submit, Miller, why your lordship is dealing with an application in Article 7, Rule 11. I am only bringing to your lordship notice, while dealing with an Article 7, Rule 11, what your lordship will have to look into is only the pleadings of the petitioner. Only the pleadings of the petitioner. Pleading means the petition and the rejoinder filed by us. The written statement and the application cannot be looked into. They are irrelevant for the purpose of dealing with Article 7 rule. That is the decision of the Supreme Court up to date. When I have given the judgment, anyway, I will give the up to date case law on the point. Article 7 rule 11. I think it's sufficient for me. I need not. The Supreme Court has laid down Miller till the last judgment was of His Lordship Justice Bopanda, 2023. All the judgments, my lord, Justice Voka, Orala, everyone say you have to look into only the pleadings and nothing else. You can't even look into. Apart from that, my lord, the important point is what the Supreme Court says is while dealing with an Article 7 Rule 11, you must presume that the averments made by the petition is true. That is what the Supreme Court has laid out. Not mine, Melon, not my interpretation. So, your lordship must presume that whatever I have stated in my petition and my rejoinder is true. And then consider the application, deal with this matter. Now, I don't think I have to repeat it suffice if I give the judgments, Melon. Should I have? Why?
Yes.
So I will make the list, only give the judgments of the Supreme Court.
You can make a.
I don't think I should waste, I feel that should I repeat, Miller? Not necessary.
You can make a note of the paragraph numbers of the judgments and give a note.
I will give it. Only the judgments of the paragraphs, I will make a list and give it.
Yes.
That's sufficient, Miller. That's for the purpose. Because there are 23 judgments up to date. All the judgments I will just give the relevant Miller, what he says is don't look it. I mean, the learned Miller, the other side is given the judgment that also says the paper book contains. The leading judgment, what he has given, Miller, is very clear, Miller. The same law has been
The order sheet. Yeah,
do the paper party's name, with relevant paragraphs on the Supreme Court judgment, I'll point out and give it to your lordship. Would it be sufficient, Miller?
Yes, yes.
Yeah. Then, Miller, no. Now the second point, Miller. So that is what we are lordship will do. What the Supreme Court has laid down, Miller, Article 7, Rule 11D, Miller, I brought your lordship notice that has been interpreted by the Supreme Court, stating that Article 7, Rule 11D means the law. Law means law laid down by the Supreme Court. Then, Miller, I have also brought your lordship notice the judgment of the Supreme Court, which says, I can question the validity of law in an election petition. I have already given Miller anyway. To refresh Miller, I pinpoint the judgment and give the paragraphs. So, Miller, what I have done in this case is, I have challenged the Balaji Subramanian's case, which the other side is relying upon. The law laid down by that court is a judgment of the Supreme Court. I am challenging the validity of the very law in this petition. That is available in view of the Supreme Court. What I am only recalling, Miller. What had happened was, my lord, a person who was a citizen of a foreign country, he had obtained a citizenship under the citizenship law. The High Court said, you can't challenge that. It is given by the competent authority, you can't challenge. Matter went to Supreme Court. The Supreme Court said the validity also can be challenged in an election petition. Law laid down. So my submission is, the law laid down by the Balaji Subramanian's case is also a law declared by the Supreme Court, and it amounts to law, and I have every right to challenge the validity of the said law before the election court. That's all right. Thirdly, in Balaji Subramanian's case, same question was raised while dealing on the arguments. The Supreme Court said, the question of jurisdiction is left open. I'll bring the paragraph to your lordship. This question was left open. So, the question of jurisdiction is not decided by the Supreme Court. I am challenging it before this court. Jurisdiction is left open. I'll take your lordship. In the very judgment, Balaji Subramanian, when the question of jurisdiction is not decided, I have every right to challenge the same before this honorable court. No, my lord. What is important, my lord, what I want to, before taking the Supreme Balaji's case, just want to read a passage by Pauline Nariman. I will give the chapter 5, dealing with you must know your constitution. That's the book written by Pauline Nariman. In chapter 5, my lord, what the learned author says, I am only reading, my lord, the last paragraph at page 389. In paragraph C, my lord. I give the paragraph, book itself, entire, I get printed and give it to your lordship. I don't know whether book is available, but I'll get it, or I will pass on the book itself, whichever. I thought the relevant chapter I could enter, I could Xerox and give it to your lordship.
I'll find out if it's in the library, it should be okay. Otherwise, the relevant chapter you can Xerox and send it. Yes.
Xerox and give it to your lordship. Entire chapter. Because if it is available in the library, well, otherwise, but I will, for convenience, for ready reference, I'll print out and get it. What this chapter says is, the precise methodology, this is how they say, while dealing with all the directive principles and fundamental rights. That's the chapter. How they have to be interpreted. In year 1992, in the principal majority judgment of the Supreme Court of India, judgment delivered by Justice Jeevan Reddy, bench decision of 9 judges, Indira Sahani, Anwar versus Union of India. The role of the preamble was also directly linked with parts 3 and part 4. That the preamble in the Constitution spelled out the goal, and both part 3 and 4 set out the methodology for reaching that goal. 40 and 3 years ago, was founded this republic with the fourfold objective of securing to its citizens justice, liberty, equality, and fraternity. Statesmen of the highest order, the like of it this country has not seen since, belonging to the fields of law, politics, and public life, came together to fashion the instrument of change, the Constitution of India. They did not rest content with evolving the framework of the state. They also pointed out the goal and the methodology for reaching that goal. In the preamble, they spelled out the goal, and in part 3 and 4, they elaborated the methodology to be followed for reaching that goal. The precise methodology to be followed by the courts was later, much later, fine-tuned. In the authoritative opinion of the court, in an anonymous bench decision of 9 judges of the Supreme Court of India in IR Koilo versus State of Tamil Nadu, reported in AR 2007 SC 861, where Chief Justice Sabarwal, speaking for the court, reaffirmed in para 49 on page 80 what had been already said earlier in 1980. The goal set out in part 4 had therefore to be achieved without the abrogation of the means provided for by part 3. Part 3, your lordship knows fundamental rights. Part 4 is directive principles. So this is the goal. The goal set out in part 4, that is directive principles, has therefore to be achieved without the abrogation of the means provided for by part 3. It is in this sense that part 3 and 4 together constitute the core of our constitution and combine to form its concepts. Anything that destroys the balance between the two parts will ipso facto destroy the essential element of the constitution. The matters have to be decided not by metaphysical subtlety, nor as a matter of semantics, but by a broad and liberal approach. We must not miss the wood for the trees. Then, 10 years later, Justice D.Y. Chandrachud, while delivering a unanimous judgment of the Constitution bench of 9 judges of the Supreme Court in case Puttaswamy versus Union of India, reported in 2017-10 SEC, upheld the right of privacy as a fundamental right under India's Constitution and went on to add in para 125 on page 411 and 412 that, as had been held in Minerva Mills case, both parts 3 and 4 of the Constitution had emerged as inseparably intertwined without a distinction between the negative and positive obligations of the state. The Constitution in this view is founded on the bedrock of the balance between part 3 and 4, and to give absolute primacy to one over the other would be to disturb the harmony of the Constitution. In essence, therefore, the goal set out in part 4 had to be achieved without abrogation of the means provided for in part 3. This is just because I didn't want to take a lordship through this is completely gives. Part 3 cannot be infringed at any cost while achieving the object of part 4, while applying directive principles. Now they say the freebies they are achieving for directive principles. To achieve the directive principles, they have a right. That is what the Supreme Court has said. They have the right. But while doing so, it shall not infringe at the part 3 of the Constitution, that is the fundamental rights. That is what has been violated, my lord, in Balaji's case. That is why, my lord, matter was challenged by Ashwini Upadhyay in Supreme Court. Supreme Court passed an order, same order they have passed, that Balaji's case violates Minerva Mills case. They have clearly held. While referring the matter, they have passed an order. That they also say reportable. That judgment is also reportable. And they not worry about it. Whatever the outcome, I am not concerned. The Balaji's case, let them decide. But the law which has been laid down by Supreme Court, while referring the matter that the Balaji's case has infringed the Minerva Mills case, your lordship is bound. I'll give that Ashwini Upadhyay's case, the referred argument. I'll also give the judgment copy better. I'll give the reported judgment. The court has asked it to be reported. They're not simply referred, they're given reasons. They say it infringes Balaji's case. Now, my lord, I have made a minute about including Ashwini Kumar's 13 cases. All are larger benches. This Balaji case is by 2 judges. 13 judgments, Miller, starting from Minerva Mills case. Miller, your lordship may recall S.R. Bommai's case, perhaps you would have, lordship would have come to Bommai's case, Miller. That is 9 judges. Head note B. Balaji's case, this Bommai's case, Miller, that deals with the manifesto only. Election manifesto pertaining to religious appeal. There's Bommai's case, if it offends, that cannot be done in a manifesto. That is of 9 judges. This Balaji's case is of 2 judges. Bommai's case is of 9 judges. Head note D clearly says, Miller, it's a very big judgment. If that is Miller, judgment would be available, or if your lordship only that paragraph I can. So 150 pages, if a lordship wants, I will type and give it, or if a lordship says that head note is sufficient, I'll give. They should not be. Whichever manner, ready reference I give. So, manifesto only. In Balaji Subramanian's case, what's the ratio? A political party has a right to give any manifesto, and that does not amount to corrupt practice is the ratio. In Balaji, in Bommai's case, 123(3), which is a religious appeal, comes to the same section. So, Supreme Court of 9 judges say manifesto cannot include. This is not considered, not even referred to, but my Minarva means not referred to in Balaji's case. So, likewise, there are 13 cases of all 5 judges, 6 judges, 7 judges. I made a note of it. All are reported cases, I instead of taking all that gist I am saying is election manifesto, authorized subject matter in Bommai's case regarding manifesto, Supreme Court has laid down it amounts to corrupt practice. So, in spite of this, all 13 judgments, the Balaji's case not referred to any one of these judgments. So, my submission is, it is per inquiry. I was not getting that word, that's why I was not getting that word, per inquiry. I was trying and I was thinking what it is. It amounted to per inquiry. So the Balaji's case is not referring to the larger bench's judgments rendered by the Supreme Court. It amounts to an honest and the lie of law. It is per inquiry and it is not a law. So, my lord, relying upon Balaji's case will not be. I think that I don't think I need take your action. I'll just give the paragraph of all of 7 judges and 9 judges. Not a single judgment is referred to in Balaji's case. So, my lord, that case cannot be looked into. No, my lord, the other argument advanced by my Ravi Kumar, similar case, same paragraphs, coordinate benches have decided Article 7 Rule 11 is hit. They have allowed. And the Supreme Court has confirmed. So I am not cannot rely upon. To begin with, my lord, in those cases, Siddaramaia's was not a party. In this case, Siddaramaiah himself is a party to the manifesto. His photograph is there. His signature is there. In those cases, it is not my case that the respondent had involved. Political party. In this particular case, how it differs from those 2 cases is election manifesto is with the respondent himself is a party. And his photograph is there. And it is by KPCC, which I have already brought your last notice. Because what is a political party defined under section 29 of the RP Act? This KPCC is not a political party under the Act. As referred to in even 29A of the RP Act is not even referred to in those cases. If they want to rely upon that it's a political party, that must be a political party as defined under section 29A of the RP Act. This is not the political party. And it's a manifesto signed by respondent himself. Then, my lord, apart from the manifesto, a handout is distributed to all voters by respondent. That handout, my lord, contains the signature of respondent herein. It is not by the political party. It is by respondent himself. That's your want, Rachit want to show that, Bella? That only 1 minute, Bella. I will not take much. Election section. I just. is, my lord, annexure F, my lord. Annexure F, my lord. My lord, it is Gruha Jyoti. Signed down, my lord, Kannada ನಾಡಿನ ಜನತೆಗೆ ನಮ್ಮ ಗ್ಯಾರಂಟಿ. Siddaramaya signed. Not the political party. Siddaramaya himself signs. For 200 units per house, house, and 2,000 rupees to every lady. I pleaded. It is not by the political party. It's a leaflet handout given to members. That means, my lord, it is a corrupt practice done by the respondent himself. Annexure F. Then, my lord, I have also given along with my document pen drive where he was giving lecture to all people. Public lecture saying, ನನ್ನ ಹೆಂಡತಿಗೂ ಇದು ಗ್ಯಾರಂಟಿ, ನಿಮ್ಮನೆ ಹೆಂಡತಿಗೂ ಗ್ಯಾರಂಟಿ, ನಿಮ್ಮೆಲ್ರಿಗೂ ಗ್ಯಾರಂಟಿ, 2,000 ರೂಪಾಯಿ ಎಲ್ರಿಗೂ. This is the speech where I have given that, none of these things are denied. This is the difference between this case and the other two cases. And in those cases, they have not given a public speech stating that I will give it on that. In this particular case, he has given. Speech has been public speech. So my submission to Lordship is those cases will not come in the way of deciding this case. That's the difference between that case and this case. This is how I said that. Then your Lordship kindly take the RP Act 123. Just a minute. One. Below section 123(8), Miller. Lordship got it, Miller? Section 123, RP Act.
Yes.
Down, Miller, below booth captain 8, your Lordship get it. Explanation. Your Lordship got it, Miller?
Yes.
In this section is 123. The expression, section is 123, madam. There are subclasses. It contains subclasses 8. In this section, the expression, what you got it, madam?
Yes, yes.
The agent includes an election agent, a polling agent. Then next is important, madam, and any person who is held to act as an agent in connection with the election with the consent of the candidate. Whereas this word agent and the role played by the agent is not the subject matter of the Balaji's case. It is my case here that the respondent acted as an agent of the candidate and with his consent. So he becomes an agent. Assuming that he calls himself a political party, he is an agent and hence they act. So it amounts to corrupt practice. This is not the subject matter. This is how, my lord, I distinguish these two cases. Then apart from that, my lord, as I brought your Lordship notice when the matters were challenged before the Supreme Court, matter came up for admission on a Friday. Unfortunately, I was in the hospital. I was attacked with a heart attack and I was in the hospital. The previous day I was operated. I was in the hospital, I did not even know the matter had come up. Nobody appeared and then the case was dismissed. When I came back after that, I came to know that the Supreme Court had dismissed. Immediately I filed the review. Review petitions are admitted, pending. Same judgment. I'll give the numbers. Apart from that, I filed 2 different petitions challenging the very previous manifestos by the same petitioner. That's also admitted by His Lordship Justice Chandrachud, and the matters have been referred to the Lordship. So they have not become final. Just for information, Miller, even assuming that they want to say that they are binding on us, just wanted to be, that's the only thing, Miller. So this are the thing. Then, Miller, the more important thing is, it is the 329 article is a bar. Under the Constitution, no matter pertaining to election can be challenged. Because article, my lord, Constitution very clear. Pertaining to election, powers are not conferred on the writ court. I brought your lordship for the provisions while arguing earlier. Articles, everything I have given. It's very clear, my lord, the powers of our, and Article 328, my lord, powers are there. And then 329, bar to interference by courts in electoral matters. So, my lord, that will be, so according to me, my lord, the jurisdiction is left open. They have no power. And the Constitution has not conferred power on the High Court to deal with a case like this. So, my lord, I forget about all these things. I'll take it that the judgment has been rendered by the High Court, Supreme Court, and it is binding. Assuming, my lord, I am arguing. Assuming, my lord, now your lordship may take the Balaji's case. My lord, the judgment has been given by the other side, my lord. Lordship is having the paper book, my lord. Yes, the paper. Other side has given, my lord. The big paper book has been given by the other side in which the judgment is enclosed.
Page number 322, my lord. Compilation filed on 18/4.
Your Honor, just take the Balaji's case, my lord. I just want your
Yes.
Honor to take. Lordship, my lord.
Yes.
The judgment page 689, my lord. Paragraph number 55. Paragraph 55, my lord. I do not know. There in printed page, my lord, 689.
Yes.
Lordship got paragraph 55, my lord.
Yes.
My lord, Lordship, can you see? What are the points there for consideration? The last point, my lord, whether the writ jurisdiction will lie against a political party. Of course, my lord, the finding your lordship would get it. At page 712.
That paragraph?
Well, the finding regarding 55.5. 55.5 is the question of jurisdiction.
Yes.
Am I right, Mala?
Yes.
Mala, the finding regarding this, your lordship will see at page 712, para 81.
Ink
Yes.
page 374, yes.
Yes.
Lordship got it, Mala?
Yes.
Yes. Mala, at the end of the last paragraph, in that said para. The correct forum is the election tribunal and not the writ jurisdiction.
Yes.
Then para 83. Last, they have the jurisdiction issue. The jurisdiction issue is left open. That's got it, Mala? Para 83 end. Para 81 end and para 83 end. I do not know whether the same paragraph.
Yes. Same paragraph. Sir.
Yes, Mala. So this is the finding regarding point number 55.2. Now, Mala, you will not come back to para 55.1.
Ink page 352, my lord.
Yes.
Got it, Mala?
Yes.
Yeah. Number 55.1, whether the promises made by the political parties in the election manifesto would amount to corrupt practices as per section 123 of the RP Act. This is the finding given, Mellon. Finding you last would get it. At para 84.1. Finding regarding that.
Three 75 page, my lord.
375 la?
Oh, the pink page.
ಅದು correct ಆದ್ರೆ I will give the page. 84.1. After examining and considering the parameters laid down in 123, we arrived at a conclusion that the promises in the election manifesto cannot be read into section 123 for declaring it to be a corrupt practice. The promises in the election manifesto do not constitute as a corrupt practice under the prevailing law. A reference to a decision of this court will be timely. In Ramchandra Kapse versus so-and-so, in paragraph 21, especially contents of a manifesto by itself cannot be a corrupt practice committed by a candidate of that party. By itself. My case is that he is acted as an agent. Leave alone that fella. This is the finding which they are relying upon. Now your lordship, I come back to 55.2, page 352. My laying page.
Yes.
Got it, Mela?
Yes.
55.2. What was the question for consideration? Points for consideration 55.2 is important, madam. Whether you ask my say, whether the schemes under challenge or within the ambit of public purpose, and if yes, is it violative of Article 14? That was the key question. The schemes which were challenged in that case, whether they came within the ambit. No, my lord, the schemes challenged in my case are entirely different. The schemes are not same in this case. So in that case, what was challenged? Court came to conclusion that they are not violative of Article 14. Now the tribal issue before your lordship is whether the schemes in this case are violative of Article 14. So this was the issue. Has to be decided. I'm not disputing, now decide. That at threshold you can't dismiss the case. Assume that manifesto political party can make. Whether the schemes in my case, what I challenged in this case, are violative of article is a tribal issue. And the election petition cannot be dismissed at the threshold. So what the finding is, that schemes challenged in that case are not in violation. That's the finding given. Not in my case. My case entirely different. Only TV, entertainment, they are not, people need entertainment, they do it. In my case, free bus, only for women, not for men. Utter violation of Article 14. 2,000 rupees only for women, not for men. Violative of Article 14. Then giving electricity connection only 200 units. Sometimes I don't get the affluence. 200 units. Then the diploma holders, only those who have passed after 223. In normal course, persons who have been waiting for 10 years without employment, they should get first. Here what they say, no, only those who have passed and those who have not secured the appointment only will be eligible for their. That is decided in Jail Singh's case, Supreme Court case, arbitrary fixation of dates. Umpteen decisions, I will give the decisions. They say you can't fix an arbitrary date, fanciful dates. It is in violation of the Constitution. Umpteen decisions are there by the Supreme Court. So all these three B's are in contravention of the Constitution. Hence, they have to be tried. The burden is on them to show it is in conformity with the Article 40. But it is on them. They admitted. They have given all they admit these freebies are given, published, distributed, given, implemented. So it is for them to justify. They are not in contravention of article. So that's why 55.2 which I read to your lordship, they were in consonance there, they are not in consonance here. It is a matter of trial and it's a tribal issue. Your lordship will have to give an opportunity to deal with the tribal issue. That's how I have come before you also. So these things are not considered in those cases. Then thirdly, Miller, what I have challenged is not only bribery. I have challenged undue influence, printing of pamphlets, or in contravention. That is my case. And incurring expenditure more than the prescribed limit. Here he has incurred expenditure more. Hence, it comes under Article 1.36. Well, how can the manifesto say how much you have to spend? Can they say you can spend 500 crores? It's a manifesto. Can it be? No, my lord. Other things, bribery, only one thing was undue influence. Then, this is how the Supreme Court laid down. So, my submission to Lordship is the other sections 123.2, undue influence, 123.4, printing of pamphlets, and expenditure incurred for giving advertisements, pamphlets, they exceeded the limit prescribed, and hence amounts of corrupt practice. That has to be decided in this case. They cannot be thrown out stating that you are not, that can't be done. Then the fourth one, which apart from this matter, 1.36 and other, I said incurred. Then now your lordship, with this, now I say they are bound by the expenditure. They are not denied that their expenditure incurred. But the earlier Nalla Kambi's case, before expenditure, how it has been, now the law has been settled, where they say even if the amount is incurred by the political party, if it is, they also have to give the note. Well, now that we are not on it, I mean, what they have to give, show it in the expenditure, stating that they have given consent and it does not. Every expenditure incurred by the party and the political party, Millard, now that after section 29A, the political parties has been included in the 10th schedule of the Constitution. No, not like early. Political party has been included in the 10th schedule of the Constitution. They become a constitutional body. They have to give the income tax returns regularly. If they don't give, they will be disqualified. What is incurred by the party, everything they have to declare. There is a difference now before and then. None of these things are discussed in the other cases. If given an opportunity, I will place all this material before this court. Besides this matter, Article 282, you cannot use the money by the consolidated fund for giving freebies. There's a method. It has to be passed like a money bill. They have taken all these grounds. They can't use it. Apart from that, I brought your lordship notice the All England Reporter's judgment, 1982 All England Reporter. Lord Denning Mellon and 5 judges of the UK have rendered the judgment stating taxpayers' money cannot be used for free distribution. 5 judges, Mellon, of UK. I think I have given, Mellon. If I have not given, I have to make and give it, Mellon. I remember to have given your lordship said it's available in the library. I don't know. If it is Mellon, if it is available, it's also a very big judgment, Mellon. If it's not there, I will type and give it to your lordship. Cannot. This is the subject matter. Now, besides this matter, what did the Balaji's case say? They did not stop at that. Your lordship, I kindly see. Page, my lord. At 376. Directions were issued. Only 4 paragraphs, but I read it. Although the law is obvious that the promises in the election manifesto cannot be considered as corrupt practice under section 123, the reality cannot be ruled out. The distribution of freebies of any kind undoubtedly influences all people. It shakes the root of free and fair elections to a large degree. The Election Commission, though, through its counsel, also conveyed the same feeling both in the affidavit and in the argument that the promise of such freebies at the government cost disturbs the level playing field and vitiates the electoral process and thereby express willingness to implement any directions or decision of this court in this regard. As observed in the earlier part of the judgment, this court has limited power to issue direction or legislate a particular issue. However, the Election Commission, in order to ensure a level playing field between the contesting candidates and candidates in the election, and also in order to see that the purity of election process does not get vitiated, has in past been issuing directions and the model code of conduct. The fountainhead of the powers under which the Commission issues these orders is Article 324 of the Constitution, which mandates the Commission to hold free and fair elections. It is equally imperative to acknowledge that the Election Commission cannot issue such orders if the subject matter of the order of the Commission is covered by a legislative measure. Next para, important para. Therefore, considering that there is no enactment that directly covers the contents of the election manifesto, we hereby direct the Election Commission to frame guidelines for the same in consultation with all the recognized political parties as when it had acted when framing guidelines for general conduct of the candidate, meetings, procession, polling day, party in power, etc. In the similar way, a separate head for guidelines for the election manifesto released by a political party can also be included in the model code of conduct for the guidance of political parties and candidates. We are mindful of the fact generally political parties release their before the commencement of election date. In that scenario, strictly speaking, Election Commission will not have the authority to regulate any act which is done before the announcement of the date. Nevertheless, exception can be made in this regard as the purpose of election manifesto is directly associated with the election process. So, my lord, after this judgment, the Election Commission convened a meeting of all the political parties and issued model code of conduct for the manifesto. That is my case. That manifesto says you can't have a manifesto assuring contrary to the corrupt practice. You can't have which is offends the Constitution. It should not offend the level playing field. My case is the respondent has violated the model code of conduct framed by the Election Commission after this case. That is not the subject matter. We are bound by the directions issued. Model code of conduct has been framed, circulated, and it is my case in my election petition that the model code of conduct has been violated. Now, the respondent in his written statement says, my lord, I have not violated. If that is so, burden is on him. So it is a tribal issue. So, my lord, my submission is this Balaji's case. We take it, entire thing is true. Even then, the freebies are different. Now it has to be examined by this court. And the model code of conduct has been issued pursuant to the directions that has been violated contrary to the articles of the Constitution. Hence, it's a tribal issue and the case cannot be dismissed at the threshold. That is in the gist manner that my case. This is my I have incorporated the model code of conduct manner, the book published manner. So far as this particular case is concerned, only few pages I've stated in my petition. But anyway, I can call out and that very pertaining to election manifesto, I don't think your lordship will want me to give the entire book. If it's the library, my lord, it need not be. But for ready reference, my lord, I can call out and then about 10 pages I can give. If
The
your lordship,
extracts will do.
if your lordship say give entire thing, I will have to make and give. Or if
No,
your
the
lordship
extracts will,
I can give. Whichever your
extracts will do.
it's relevant,
Extract will do.
I will make and give. Because it's a big book, my lord. It's published by the election committee. That's why, my lord, my case, it differs. Apply the very Supreme Balaji's case and then do it. Entire thing contrary to my lord. So, one matter, apart from that matter, I'm so sorry, my lord, widow's pension not given. Old age pension not given to ladies. Salaries have not been given to ladies. So many things, my lord, today also. So, because now Sri Lanka has gone to dogs. I have got the entire authoritative article how it because of the freebies. Pakistan has gone to drugs because of the freebies given. California has gone to in a difficult position. For that matter, even New York has gone. That Venezuela, my lord, freebies. Now they are begging. They don't have money to feed. My lord, now our apprehension. If these things are done, where will we go? If whether we should take our state for that position. As it is, 54,000 crores is being used for the freebies. It's a matter of record. 54,000 per year. Freebies. Not sanctioned by the budget manual. Not approved by the Auditor General. Finance Commission has not approved. I stated all my petition, not my argument. I stated my petition. Article 282 of the has been violated. If they want to have a scheme, how a scheme has to be made is narrated in Beam Singh's case. That also I stated in my petition. Beam Singh's case, my lord, there. Central government, you will also make a see. Unemployed people, the NRGA, for 100 days the salary is to be given. That was challenged in the Supreme Court, in Beam Singh's case. They said, you can't give free. Then the Supreme Court, in Beam Singh case, entire thing was considered and they said, in this particular Beam Singh's case, in giving that NRGA, the Parliament has passed the law, approved. Law has been passed in accordance with law. They made provision for the payment. Hence, it is valid. That is Beam Singh's case. Here, nothing. In this case, no provision, budget manual violated, contrary to Beam Singh's law, contrary to the Auditor General's opinion, Finance Commission's opinion, not even passed like a money bill, according to your wishes, as though you can give it. You can't give like that. You can't take from him and give it to somebody. Well, of course, apart from that, I have taken one more contention I need now. According to my lord, starting from Bhishma's my lord, in what Bhishma says, when the people go and ask him, he says, what is the greatness of a work? Without work, no salary. Whatever it is. In my lord, in America, my lord, the previous president was there. Same thing, they wanted freebies to be given. He said, no, without work you can't give it. Then the people, the senator said, where is the work to be given? There is no work. How can you provide work? The president president said, he says, Dige, Gundi Tagiri, open the gate, pay him. Then people and pay him. No one without work. That is what the President of America said. Without work you can't give. Work is paramount. That is what Lord Basavana said. Without work is worship. That is what Narayan Guru said. That is why the Chinese said, when they wanted to give a fish melon, they said, don't give a free fish. Show him how to fish so that he can have a living. Show him how to fish so that he can fish, sell it and live. That is how, my lord, the theory of work has been strengthened and examined and told by the philosophers of the great people, starting from Nehru, starting from Falkiwala, all the quotations are quoted. Cannot give. This is why, my lord, I am before your lordship. This is a matter which has to be decided and it cannot be dismissed at threshold. And it has got. These are the facts. Whether I am able to prove or not, that ultimately the matter will repeat. So Article 7, Rule 11 is not amenable at this stage and it cannot be dismissed allowed at this stage, stating that the Balaji's case has decided and it has been approved. This is in turn, my lord, my submission. I am grateful to your lordship. I just wanted to express these are the things which I wanted to submit before the lordship. These are the things I'll make it and give it, my lord.
Yes.
My difficulty is, where should I file it, my lord? In another case, where the matter was pending in the Gulbarga case, when I wanted to file in Bangalore, they said, no, we don't receive it. Go and file in Gulbarga. This matter is of Bangalore. I can't file in Gulbarga, I can file only in Bangalore. Whichever if your lordship says, send it to Gulbarga, I will send it. Or if your lordship says, I can file in Bangalore, I will file it in Bangalore.
It can be filed in Bangalore. Can you make a e-filing?
No, that's what they said. That last time I inquired money in the Gulbarga case. They said, no. What they said, you file there, the registrar will send it to the honorable judge. That's how they said, whatever your lordship says, I will do it, my lord. If I give it, then they will forward it to your lordship. If I,
Yes.
or if your lordship say e-file, I can do it to the registrar of Gulbarga. I will do it from my office. Whichever your lordship says, my lord, I will obey. But your lordship may tell.
If it's physically filed in Bangalore, we'll get it.
Yes, my lord.
In addition, if it is possible,
What
soft copy
one physical
can be sent to ARG Gulbarga. Email ID. Soft copy can be emailed to the ARJ Gulbarga. We will Kalaburagi. We will forward. I will forward the email ID. I will forward the email ID through my office.
If it's forwarded, I will do it. One set I will send it to their mailer, and another I also file a physical copy.
Yes.
This is what I am doing with that.
Yes.
Grateful to your lordship.
Heard.
Your lordship wants me to the articles of all these 4 countries are collected, mailer. Beautiful judgments, how it is affected. If your lordship permits, I will find those judgments also. The articles of all these countries, Sri Lanka, Pakistan, then all the countries, Venezuela, I have, my lord. I am so worried because my state should not go to that. As it is, my lord, some of the industries have gone out of Karnataka. Tesla, they wanted to have it here, they went. They said, well, only very much, I leave it to your lordship. It is in the lordship's hands to protect our state, protect the money of our state. And that's all my endeavor, my lord, before your lordship.
Heard.
I'll make it, my lord. My lord, the emails in proper shape, my lord.
We'll send it. I'll send it. I'll have it sent.
Email ID, I just want it.
Third learned senior counsel is Pramila Nesari on behalf of the petition.
I could send somebody also and file it. I will see, my lord. If I can send somebody instead of email, I thought I could send. I will make everything copy. On Tuesday, I will send it, my lord. I'll ask the party to come on Monday. I'll ask him to take it in person because in one more case also I have to give it.
Yes.
So both the judgment, my lord, I will send it. Personally, I will send it, my lord, to an advocate. And he will give it to the registrar with my advocate's on record signature.
Yes. Arguments are concluded from both sides. Matters reserved for orders on IA 1 of 23. Written submissions if any, to be filed within 10 days. Within 10 days. The matter will be proceeded for judgment after 10 days.
Grateful to you.
Grateful, my lord.
Case had come for consideration before His Lordship Justice Chandrachud. Balaji's case. Two more judgments, my lord, they have considered. There also they say unless it's violated, if a lordship, this case, I have it, not reported, unreported, then I have to give the, if a lordship say, I will give that judgment, so considered by His Lordship Justice